It's an interesting little thing. The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on H.R. 5, the Equality Act. I will now recognize myself for an opening statement. Nearly 50 years after the Stonewall Uprising, there is still no federal law that explicitly prohibits millions of lesbian, gay, bisexual, or transgender Americans from being denied medical care, being fired from their jobs, or thrown out of their homes simply because of who they are. It is time Congress changes that. Today, the Judiciary considers H.R. 5, the Equality Act. This is long overdue legislation that will explicitly prohibit discrimination against LGBT and gender nonconforming Americans and will strengthen non-discrimination protections for women and others. Today's hearing also affords us the opportunity to hear about the enduring nature and extent of continuing discrimination faced by LGBT people in various aspects of American life. In 2015, as part of its decision in Obergefell versus Hodges, which recognized the fundamental right of same-sex couples to marry, the Supreme Court held, quote, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity," close quote. The Equality Act will help protect and defend that liberty for LGBT individuals, women, and others. At this moment, we have an opportunity to continue our march towards justice, to enshrine in our nation's laws protections for marginalized communities, to ensure that they can fully participate in key areas of life, and to provide them recourse in the face of discrimination. The Act will do so by amending our existing statutes, namely the Civil Rights Act of 1964, the Fair Housing Act, the Equal Credit Opportunity Act, the Jury Selection and Services Act, and several laws regarding employment with the federal government, by either adding sex, including sexual orientation and gender identity, as a protected characteristic, or where sex is already included as a protected characteristic, by explicitly clarifying that sex discrimination includes discrimination on the basis of sexual orientation or gender identity. It will also expand the Civil Rights Act of 1964 to clarify the definition of public accommodations and to ensure that a broader range of establishments, including retail stores and services such as banking, are included for all classes. All forms of discrimination are tied together, and we must address them together. If a black lesbian couple is denied housing they are otherwise qualified for, it is nearly impossible to tell if they were turned away because of their race, their gender, or their sexual orientation. It is time we make clear that none of these are acceptable forms of discrimination. We have already seen the effectiveness of non-discrimination provisions on the federal level, and we have seen how sexual orientation and gender identity protections work in the more than 20 states that have them on the books. There is no reason discrimination that is explicitly illegal in one part of the country should not be explicitly illegal in all parts of the country. The Equality Act builds on these existing protections and provides clear recourse for millions of people, no matter where they live. The Equality Act takes special care to maintain the careful balance long established between individual liberties and our compelling interest in promoting non-discrimination. Freedom of religion is a fundamental American value, and we do not have to choose between non-discrimination and religious liberty. We have in our existing civil rights laws a roadmap on how to advance both. Religion is no excuse for discrimination, as we have long recognized when it comes to race, color, religion, sex, and national origin. And it should not be when it comes to sexual orientation or gender identity. Many of the arguments against the Equality Act are belied by the experience of the states and localities that have protections already. The scaremongering about potential bathroom predators has not turned out to be true. Protecting the ability for a transgender person to use a facility consistent with their gender identity has not weakened public safety or criminal laws or undermined their enforcement. Similarly, protections for sexual orientation and gender identity will not force religious hospitals or nonprofits to close. New York has these protections. We have Catholic, Jewish, and Protestant hospitals and adoption agencies. And everyone, regardless of who they are or whom they love, is able to receive medically appropriate care and to be served by publicly funded organizations. Many states have sexual orientation and gender identity non-discrimination laws, and all of them still have women's sports. Arguments about transgender athletes participating in sports in accordance with their gender identity having competitive advantages have not been borne out. Sports have positive impacts on physical, social, and emotional well-being, and we should not be denying transgender athletes those opportunities simply because sometimes they may win. Nor should their occasional success be used as a roadblock to advancing civil rights legislation for LGBT people as a whole. While we are examining the specific provisions of this legislation, the true question before us is much broader and goes to the heart of the country we want this to be. Much of the history of the United States has been expanding the definition of who is understood to be included when the Declaration of Independence says all men are created equal. When these words were first written, that phrase did not include Black and Latino men. It did not include Native Americans. It certainly did not include women, and it did not include LGBT individuals. But we have, as a nation, aspired to expand the definition and ensure that regardless of race, creed, ethnicity, or sex, everyone is able to participate fully in the American way of life. Each advance has been hard fought, whether in Congress, in the courts, or through regulations, or even in a civil war. And it has happened over the objections of people who argued that we were taking away their freedom to discriminate. But as a nation, we have long held that we cannot sit by and be tolerant of intolerance that is designed to demean and to exclude communities. That is why I am a proud co-sponsor of the Equality Act. Before I end, I want to take a moment to directly address many of those watching today's hearing who are undoubtedly about to hear their humanity and their right to exist questioned. To the transgender and nonconforming youth, teens, and adults who are about to hear their right to participate in sports and to be themselves in school, work, and in their daily lives challenged. To the same-sex couples who are about to hear suggestions that they just take their business elsewhere, that they adopt children elsewhere, that they exist elsewhere. We see you, we support you, and we believe in you. If you are feeling unsafe, afraid, or at risk, please reach out for help. You are worth fighting for, and we are here to fight alongside you, which is why we will be passing this bill. I want to thank the gentleman from Rhode Island, Mr. Cicilline, for introducing this important legislation, and I look forward to hearing from all of our witnesses. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman, and I look forward today to the really incredibly weighty issue that we do have here in this hearing today, but I also want to note, because not just from Republican circles or others, the humanitarian security crisis still at our southern border rages on, and we've done nothing to address the danger to migrant children and to the American citizens. And this is not just coming from me, this is from the Washington Post, this is from the New York Times and others. So I do look forward to us getting to that as we go forward, just as we're getting to this incredibly weighty issue today as we go forward. Everyone here can agree there's much suffering in our world. Today we have the opportunity and obligation to listen to people with different perspectives on how to address it. As we do that, we stand on the shoulders of the civil rights heroes who fought before, like us, like two of my colleagues here. I'm from the Atlanta area, and I've watched over my lifetime as our country has recognized and responded to the disadvantage historically borne by racial minorities and women. We are not here today to betray the Civil Rights Act, but to uphold its ideals. There is no doubt in my mind that men, women, and children who experience gender dysphoria suffer deeply. Unfortunately, the legislation we're considering would harm countless people who understand themselves to be transgender and would demolish the hard-won rights of women, putting them once again at the mercy of any biological man who identifies at that any moment as a woman. The biological differences between the sexes remain scientific and certain. Men are physically stronger and faster than women, which has made it necessary for women to access clear legal protection. When any man can enter into a protected space and status is identifying as a woman, as noted by Women's Liberation Front leader, H.R. 5 nullifies women's and girls as coherent legal category worthy of civil rights protection. The bill privileges the rights of men who identify as women over biological women and girls. Consider female sports. Last year, 2 male athletes won the top 2 spots in Connecticut girls Class S indoor track meet. Female athlete Selena Soule, who finished 8th, missed an opportunity to compete in front of college coaches by 2 places. In Selena's words, "We all know the outcome of the race before it even starts. It's demoralizing." Allowing men to compete against women in women's sports isn't demoralizing because female athletes like Selena aren't talented. It's demoralizing because it makes their talent irrelevant. Martina Navratilova explained the threat of H.R. 5 poses to women's sports. Unless you want to completely remake what women's sports means, there can be no blanket inclusion rule. There is nothing stereotypical about this. It's about fairness and it's about science. In fact, H.R. 5 ignores fairness and denies science in order to codify stereotypes and sexism. If a man who adopts the mannerisms associated with women can receive every federal protection afforded to women, we've reduced womanhood to a set of stereotypes. The same stereotypes some men have chronically exploited for social, professional, and political advantage. H.R. 5 plays into these things that hurt women and girls across every dimension of our society, and it would give these stereotypes the trump card whenever tensions arise between the rights of a transgender person and the rights of a biological woman. The damage H.R. 5 would inflict on vulnerable Americans isn't limited to women. Administering chemotherapy to a healthy, cancer-free patient is malpractice, but H.R. 5 could compel doctors to prescribe hormones and perform major surgeries on adolescents based on their gender identity rather than the biological gender or medical condition. Under this bill, adolescents who can't decide what major to pursue in college would be empowered to force doctors bound by anti-discrimination laws to administer hormones that could render these children sterile and conduct irreversible surgeries. Mothers and fathers who have watched their children deteriorate physically and emotionally as they transition away from their biological sex are begging Congress to listen before we leap. Don't ignore the cost here, because they are steep. H.R. 5 erases civil rights protection for biological women and sets the stage for children to fall victim in permanent and unprecedented ways to the confusion that often characterizes adolescence. If the Democrats are determined to move this legislation forward anyway, we must acknowledge it automatically privileges the rights of biological men over the rights of biological women. This bill will cause suffering that is far-reaching and in many cases enduring. Though the women and children have historically been uniquely vulnerable, Democrats are condemning people who advocate for their rights and against H.R. 5 as bigoted. The ideology-driven H.R. 5 is content to see women, lesbians, and families become the collateral damage of identity politics with no basis in science. So I'd ask my friends across the aisle not to peddle that notion under H.R. 5, everybody wins. There will be many losers because H.R. 5 bows to the political expediency that silence calls for fairness, flouts science, and has no compassion for the women and children it marginalizes. And as a ending to my chairman's comments, there's nobody in this world should be mistreated for how they see themselves or how they portray themselves. I believe that that is a gift that is inherently from God and is a spark of life that is put in there not by any man or woman or anybody created, it is by the one that creates. Understanding that, we can have differences. We can understand things differently. And we can understand when it comes to the law how laws affect some and hurt others. That is not being mean-spirited, that is not being hurtful, that is just being honest. And they can have discussions today, and we plan on having those discussions, and I appreciate everybody's perspective that's going to be here. But to challenge the motive of what my disagreement may be as to people that I don't even know and that I could come to love and care is wrong. For me, this is about looking at a bill and saying what is right or wrong about this bill. And when we understand that, we can have bigger discussions as we go forward. That is where you have true conversations of love. That is where you have true conversations of compassion. And we can disagree on that, but talk about a bill that inherently does have bad effects intended with it. As we go forward, I look forward to the discussion. I look forward to our side and both sides having this discussion. I appreciate the chairman's time. And with that, I yield back.
I thank the gentleman. I will now introduce today's witnesses. Sunu Chandy, I hope I pronounced that right. Sunu Chandy is the legal director for the National Women's Law Center. She earned a Bachelor of Arts degree from Earlham College, a law degree from Northeastern University School of Law, and a Master of Fine Arts from Queens College. The Reverend Dr. Dennis Wiley is Pastor Emeritus of the Covenant Baptist United Church of Christ. He earned a Bachelor of Arts from Harvard, a Master of Divinity from Howard University, and both a Master of Philosophy and a PhD from Union Theological Seminary. Carter Brown is the founder and executive director of Black Trans Men, Inc., a nonprofit organization dedicated to empowering African American transgender men. Prior to serving in this role, he worked in real estate and mortgage banking for over 10 years. Julia Beck is a member of the Women's Liberation Front and the former Law and Policy Co-Chair of Baltimore City's LGBTQ Commission. She earned her Bachelor of Science degree from Towson University. Dorian Lambelet Coleman is Professor of Law at Duke Law School. She earned a Bachelor of Arts from Cornell and a law degree from Georgetown University Law Center. Jamie Contreras is a supervisor at an auto finance company in Michigan. She and her wife encountered difficulty obtaining medical care for their newborn child because of their sexual orientation. Tia Silas, did I pronounce that right? Tia Silas is Vice President and Global Chief Diversity and Inclusion Officer at IBM. She earned a Bachelor of Science degree from Cornell University and an MBA from NYU Stern School of Business. Kenji Yoshino is the Chief Justice Earl Warren Professor of Constitutional Law at NYU, that's New York University School of Law. He earned a Bachelor of Arts from Harvard University, was a Rhodes Scholar at Oxford University, and earned a law degree from Yale Law School. We welcome all of our distinguished witnesses and thank them for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in. Please raise your right hands. Do you swear or affirm, under penalty of perjury, that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? So help you God. The witness, thank you. Let the record reflect the witnesses all answered in the affirmative. You may be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals the 5 minutes have expired. Ms. Chandy, you may begin.
Good morning, Chair Nadler, Ranking Member Collins, and members of the Judiciary Committee. Thank you for the opportunity to provide testimony in support of H.R. 5, the Equality Act. My name is Sunu Chandy. I'm the legal director of the National Women's Law Center. The center has worked for more than 45 years to advance women's equality and to remove barriers created by sex discrimination. Before joining the center, I served in senior leadership roles at federal and local civil rights agencies, and for 15 years before that, I was a civil rights litigator. I have been active with LGBTQ organizations, including currently as a board member with the Transgender Law Center, and in the past as a leader with South Asian LGBTQ organizations. A few years ago, when my daughter's first grade classmate said to her on the playground, "But wait, you can't have two moms," I am so proud that my daughter went to the principal and got her from the side to help explain that yes, in fact, she can. We are urging Congress to pass the Equality Act so that all kids can have legal protections, no matter their family structure. And as with any bill that seeks to amend existing civil rights laws, the Equality Act must be enacted in a way that expands and never retreats from our commitment to existing civil rights protections. Support of the Equality Act is key to the National Women's Law Center's mission and critical for our collective liberation against sex discrimination, as outlined here. First, the Equality Act would provide explicit protections for LGBTQ people in employment, housing, credit, education, public spaces and services, federally funded programs, and jury service. The U.S. Supreme Court has long recognized that discriminating against someone because she does not conform to gender stereotypes is sex discrimination. The Equality Act would make these protections for LGBTQ individuals explicit in federal statutory law. Second, the act would ensure that all women, including LGBTQ individuals, would gain protections against sex discrimination in public spaces. This means individuals, including those who are pregnant, who experience sex discrimination, including sex harassment, while in spaces such as restaurants or stores, would have a legal remedy through the Equality Act. Third, the act would ensure that individuals gain new protections against sex discrimination by entities that take federal dollars. Schools, community centers, homeless shelters. The Equality Act would prohibit sex discrimination in these spaces. Finally, the act ensures additional protections in public spaces that they extend to all relevant entities. People of color continue to face discrimination regularly in stores or when seeking taxis. The Equality Act would prohibit this kind of discrimination. The act protects freedom of religion also through existing thoughtful exemptions contained within the federal civil rights statutes that protect religious actors from government intrusion. For example, the current laws exempt private entities that are not open to the public. Churches can hold services, spaghetti dinners, and limit their entry to their members. The current law allows religious entities to limit employment to members of their own faith, and they require religious accommodations for employees. The current law also provides that religious entities are exempt from fair housing laws if they're using a dwelling for a non-commercial purpose or in small buildings where the owner lives on the premises. In addition to maintaining all these religious exemptions, the Equality Act clarifies that the Religious Freedom Restoration Act cannot be misused to allow violations of federal civil rights laws. This does not eliminate RFRA, but limits its reach so it can't be used to defend against civil rights claims. The Equality Act represents a significant advancement for all women and girls, and I want to be clear. The National Women's Law Center supports the Act's requirement that transgender women and girls be included with other women and girls in gender-specific spaces, including in sports programs. Our country has a history of attempting to justify sex discrimination by asserting that it's protecting women. Just as this rationale fell short when excluding women from opportunities, it does not work now. The National Women's Law Center has represented women and girls seeking athletic opportunities, equal employment, and protection from sexual violence for decades, and this includes women and girls who are transgender. We are firmly committed to advancing the Equality Act because it will advance opportunities for all women and girls. As a woman, a person of color, and a parent in a two-mommy family, I need the Equality Act. And as the daughter of a Christian minister and school teacher, immigrants from a small village in Kerala, India, it has been quite a journey towards family acceptance. Gaining explicit federal law protections provides not only legal rights, but an increased measure of dignity. Over decades, through the courage of individuals coming forward with claims of discrimination, we have collectively expanded the scope of civil rights protections as one tool in our work for justice. We urge Congress to pass the Equality Act. Thank you.
Thank you, Reverend Wiley, I'm sorry.
Good morning. My name is the Reverend Dr. Dennis W. Wiley, Pastor Emeritus of the Covenant Baptist United Church of Christ in Washington, D.C., which I pastored along with my wife, the Reverend Dr. Christine Y. Wiley, for 32 years. I am a liberation theologian, a community activist, and a social justice advocate. As a religious leader, I am here today to express my full, unequivocal support of the Equality Act. My support is based on my religious upbringing, my personal experience, and the influence of prophetic trailblazers like the Reverend Dr. Martin Luther King, Jr. In a speech titled The American Dream, delivered at Lincoln University in 1961, King observed that while morality cannot be legislated, behavior can be regulated. In other words, according to King, it may be true that the law can't make a person love me, but it can keep that person from lynching me. Born and raised in Winston-Salem, North Carolina until the age of 14 during the 1950s and 60s, I never witnessed the horror of lynching, but I did experience the injustice of racial segregation. Because of the color of my skin, I lived in a segregated neighborhood. attended segregated schools, shopped at segregated stores, ate at segregated restaurants, drank from segregated water fountains, used segregated restrooms, rode segregated buses, and sat in the balcony of a segregated movie theater after entering the side door and climbing 14 flights of stairs. And while I was constantly surrounded by the love of family, neighbors, church members, teachers, and friends, I could not help but notice that there was a sharp line of division, primarily between the black world in which I lived and the white world to which I was exposed only through television and in the movies. And so, to add insult to injury, courts and the public framed laws enforcing segregation and banning interracial marriage as morally sound and founded in Christian heritage. And so it was not until I moved to the nation's capital in the same year that the 1964 Civil Rights Act was passed that I experienced white teachers, white classmates, and integrated public facilities for the very first time. And it was from that vantage point that my soul was able to look back and find solace in the slow and usually begrudging American evolution from a country in which systemic racism permeated our laws to one with comprehensive civil rights protections in employment, public accommodations, and at the ballot box. All too often, the racist laws that reinforced racism were justified and maintained by arguments purportedly rooted in religion. And the same is true for laws that fail to protect our LGBTQ brothers and sisters from those who would condemn them for who they are and who they love. When my wife and I accepted the challenge to lead Covenant to become a beloved community that welcomes and affirms all, including LGBTQ persons, I was reminded that King once said, "Cowardice asked the question, is it safe? Expediency asked the question, is it politic? And vanity comes along and asks the question, is it popular? But conscience asked the question, is it right?" Well, we did what we did at Covenant, not because it was safe, politic, or popular, but because we believed it was right. And I feel the same way today about supporting the Equality Act. As our LGBTQ brothers and sisters move around this nation, they should never have to fear losing a job, being evicted from a house or apartment, refused service at a restaurant, denied approval for a loan, or rejected admission to a school because of their sexual orientation or gender identity. And so in closing, I am reminded that a couple of years after we agreed to perform union ceremonies at our church, we went to New York to see our younger daughter act in a play toward the end of her second year at Juilliard. Shortly after we arrived in the city, she stopped by our hotel room for a visit because she said she wanted to share something with us. It was then that she came out to us as a lesbian. We were shocked because we did not see this coming. However, I immediately got up, went over to her, gave her a big hug, and told her how much I loved her. My wife was a little slower responding, not because she was disappointed or upset, but because being a mother, she was afraid of what danger our daughter might face. Well, I'm happy to tell you today that my daughter, Samira Wiley, is doing just fine as a successful Emmy Award-winning actress who is happily married to the love of her life, Lauren Morelli. Not every LGBTQ kid is as lucky as Samira, but when I told Samira that I would be giving this testimony today, she wanted me to be sure to tell you that if we, her parents, had not accepted her for who she is, she would not have the courage, the confidence, or the self-esteem to be not only a successful actress, but also a positive role model for other LGBTQ persons. So let's make sure that the Equality Act becomes law so that all of our beautiful, promising, gifted LGBTQ citizens, just like my daughter and daughter-in-law, can live their lives free of fear, free of bigotry, and free of discrimination.
Thank you very much, Mr. Brown.
My name is Carter Brown, and I'm honored to submit this testimony in support of the Equality Act and in support of the millions of hardworking Americans whose livelihoods have been threatened by the lack of clear, permanent workplace protections. Each day, workers across the country are subject to anti-LGBTQ discrimination and harassment that denies them the fair chance to earn a living. I know this because it happened to me. I once believed that I was the embodiment of the American dream. My early days were spent in a family that lived paycheck to paycheck, struggling to keep food on the table. I had even briefly experienced homelessness at the age of 14 while a student in high school. Determined to break the cycle of poverty, I fought hard to earn my diploma and was the first in my family to go to college. I learned I had a penchant for real estate and entered the field determined to be a success story. In the following years, I married my best friend and we welcomed our daughter into the world. I felt a responsibility, as many new husbands and fathers do, to provide for my family. So I continued to work hard and establish myself in my career. I earned 3 promotions in only 2 years, enabling me to purchase our first home. These visual markers of success were proof that the American dream had not eluded me, but that it was clutched firmly in my hand. And then one day, I arrived to work and discovered that a coworker had outed me as a transgender man. Everything around me shattered. In the months that followed, I was the subject of cruel office gossip and forced to endure invasive and defensive questioning from colleagues on the subject of my identity. When they weren't asking me to use other bathrooms or questioning me about my private life, my coworkers excluded me from work lunches and avoided me in the halls. I was suddenly isolated in a field where communication and teamwork was essential to doing my job. To my coworkers, being transgender eclipsed everything. I began to dread coming into work and often spent lunch breaks alone, crying in my car. I was fired shortly after, and despite my previous achievements and excellent work performance, my termination from work was lawful. In my home state of Texas, there are no explicit state statutes prohibiting discrimination on the basis of sexual orientation or gender identity. In fact, 30 states in total, that's more than half of the country, have no statutory protections whatsoever for LGBTQ workers who do experience discrimination in the workplace. How can the American dream be realized when a majority of states have failed to extend equal access and equal opportunity to its citizens? My experience left me embarrassed and vulnerable. I was overwhelmed trying to cope with the crushing lack of financial security. As a result of being fired, I was forced to cash out my 401k and defer auto loans and mortgage payments just to keep my family afloat. We lost our health insurance and had to depend on Medicaid to care for my daughter's special health needs. It would be an understatement to say that the loss of my job caused my family significant economic and emotional turmoil. In my experience, it's not uncommon. LGBTQ Americans rightfully fear being outed at work will cause them to lose their jobs, be passed over for promotions, or suffer lost wages. It should come as no surprise that more than half of LGBTQ workers hide their LGBTQ identity at work. The Equality Act is simple. It amends existing civil rights law to include sexual orientation and gender identity as protected characteristics to provide consistent and explicit non-discrimination protections for LGBTQ people across key areas of life. In addition to these changes, the Equality Act updates the Civil Rights Act to more fully reflect the way we live our lives today. This amendment to the Civil Rights Act simply modernizes protections that would not only protect me as a transgender man, but my family and many people who I love. Texas is one of the only 5 states in the country that has no state-level public accommodation statute. This means that my family can still be denied service at a store or by a public car service because of my race without any legal recourse, for example. All Americans, regardless of sexual orientation or gender identity, need permanent and explicit non-discrimination laws to protect them in the workplace. If the Equality Act had been in place during my employment, it would have been illegal for my employer to engage in harassment and fire me because I was transgender. My family would not have had to shoulder the burden of my loss of income and worry about my emotional health. I understand that not everyone shares my values, and I may never change their minds, but we can change the law. A person's sexual orientation or gender identity has nothing to do with their ability to do their job, but now because there are no clear federal protections in place for LGBTQ workers, Passing this historic piece of legislation has everything to do with our survival. Thank you.
Thank you. Ms. Beck?
Thank you to Chair Nadler, Vice Chair Scanlon, and Ranking Member Collins for welcoming my testimony in consideration of the Equality Act. If the Act passes in its current form as H.R. 5, then every right that women have fought for will cease to exist. H.R. 5 is a human rights violation. Every person in this country will lose their right to single-sex sports, shelters, grants, and loans. The law will forbid ever distinguishing between women and men. To be clear, I do support the general goal of the Equality Act, to protect people on the basis of sex, of physical and immutable biological reality, to protect sexual orientation, which is based on biological sex. I object to the inclusion of gender identity. People who call themselves transgender, non-binary, and everything in between still deserve the same basic human rights that we all do. But treating someone as if they are a member of the opposite sex is not a civil right. In fact, this violates the rights of others. People cannot change sex, no matter how many legal documents they alter, no matter how many dangerous surgeries they endure. This myth of changing sex has gained considerable traction, not only because of the synonymous use of the words sex and gender, but also because trans activism is extremely well-funded, with billionaire donors and a very deep sea of lobbyists. Sex is a vital characteristic, gender and identity are not. Sex can never be changed, but gender changes all the time. 100 years ago, pink was a color for boys. Now pink is a girl's color. This is an example of gender, social expectations of appearance and behavior. These expectations are based on sex stereotypes that prevent people from being their authentic selves. Unfortunately, gender identity forces people back into these stereotypical sex roles. This bill defines gender identity as actual or perceived gender-related characteristics. This is a circular definition, a logical fallacy. There is no way to protect a person on the basis of their gender identity without a legitimate definition. Lawmakers across the country will have to consider which mannerisms, hairstyles, occupations, and clothing choices make up one gender identity or another. How is this any different from the sex stereotypes women have been fighting to break free from? How is this not regressive? The concept of gender identity suggests that there is an essentially female personality or feeling that a person can have, but no such thing as a female body. Making gender identity the law will in fact mandate a belief in a female penis or female testes. The concept of, deep down, I believe you have good intentions, but gender identity only does harm. Let me tell you what happens if H.R. 5 passes. Male rapists will go to women's prisons and will likely assault female inmates, as has already happened in the UK. Female survivors of rape will be unable to contest male presence in women's shelters. Men will dominate women's sports. Girls who would have taken first place will be denied scholastic opportunity. Women who use male pronouns to talk about men may be arrested, fined, and banned from social media platforms. Girls will stay home from school when they have their periods to avoid harassment by boys in mixed-sex toilets. Girls and women will no longer have a right to ask for female medical staff or intimate care providers, including elderly or disabled women who are at serious risk of sexual abuse. Female security officers will no longer have the right to refuse to perform pat-down or intimate searches of males who say they're female. And women undergoing security checks will no longer have the right to refuse having those searches performed by men claiming a feminine identity. For a good look at how lesbians are impacted by gender ideology and legislation, please read Lesbians at Ground Zero, a survey from the UK about the harassment of lesbians in queer spaces, which I request to be placed in the hearing record. Everything I just listed is already happening, and it's only going to get worse if gender identity is recognized in federal law. The authors of this bill have done a lot of work to make it sound like gender identity is well understood and has been around for a long time, but it's a new concept that can only ever refer to stereotypes and unverifiable claims. The witnesses for the majority will talk about medical conditions and desperate unhappiness that everyone is surely sympathetic to, but this bill doesn't reference any medical condition, and unhappiness isn't a sex class, nor is it a reasonable category of civil rights protection. Everyone experiences unhappiness. So I would ask the members to strike the gender identity provisions of this bill and instead consider protecting all forms of self-expression and loving relationships under stronger sex stereotype discrimination provisions. Sex stereotype non-discrimination could equally cover both RuPaul and Caitlyn Jenner in their rights to housing and employment, but only if we accurately recognize everyone's biological sex. I thank the Republicans who invited me here, and I urge my fellow Democrats to wake up. Please acknowledge biological reality. Thank you for your time.
Thank you, Professor Coleman.
Good morning. Thank you for inviting me to testify today. My name is Dorianne Coleman. I'm a professor of law at Duke Law School, and I support equality. As Chairman Nadler noted, the legal history of our country is in part a chronology of efforts designed to give meaning and effect to the original commitment in 1776, all men are created equal. The work is ongoing for those of us who weren't originally meant to be its beneficiaries. As the milestones reflect, the lesson is that different groups experience inequality for different reasons at the hands of different people and in different ways, so that tailoring an effective remedy requires attention to those differences. Although the nation benefits as equality expands, in fact, only some of us needed the Emancipation Proclamation and Brown versus Board of Education. Only some of us need Title IX and the Violence Against Women Act. Approaches to equality that elide relevant differences are not only ineffective, they actually serve as cover for ongoing inequality. I've recently encountered advocacy that exemplifies this problem. The argument is that because some males identify as women, some women have testes. From this, it follows that sex and sex-linked traits can't be the grounds for distinctions on the basis of sex because this excludes women with testes. This leaves gender identity as the only legitimate basis for classifying someone into, for example, girls and women's only spaces and opportunities. I support equality, including for the LGBTQ community, but I don't support the current version of H.R. 5 because I say this with enormous respect for everyone who's working on the bill. It elides sex, sexual orientation, and gender identity. It's all sex discrimination, and at least impliedly, we're all the same. In opting for what is in effect a sex-blind approach to sex discrimination law, the legislation would serve as cover for disparities on the basis of sex. Sex is not just a concept. Females have and continue to be treated differently precisely because of our reproductive biology and stereotypes about that biology. The legal fiction that females and women with testes are the same for all purposes will take us backward, not forward. I was asked to testify today because I've long worked in the one area where this is most clear, Title IX and opportunities for girls and women in sport. Title IX, which requires schools to invest in male and female athletes equally, undoubtedly powers invaluable outcomes, not only for the many individuals who are benefited by its terms, but also for society in general. Those of us who are athletes know that separation on the basis of sex is necessary to achieve equality in this space. With respect, among scientific experts, it's accepted beyond dispute that males and females are materially different with respect to the main physical attributes that contribute to athletic performance. They agree that the primary reason for sex differences in these attributes is exposure in gonadal males to much higher levels of testosterone during growth and development and throughout the athletic career. This literally builds the male body in the respects that matter for sport. The first figure in my statement shows what we mean by much higher levels of testosterone. The second demonstrates how sex differences in athletic performance emerge coinciding with the onset of puberty. And the third illustrates the effects of those differences, again starting in adolescence. The third marks the individual lifetime bests of 3 female Olympic champions in the 400 meters, including Team USA's Sonia Richards-Ross and Allison Felix, in the sea of male-bodied performances run in the single year 2017. It shows that the very best women in the world would lose to literally thousands of boys and men, including to thousands who would be considered second tier in the men's category. And because it only takes 3 male-bodied athletes to preclude the best females from the medal stand, it doesn't matter if only a handful turn out to be gender nonconforming. If U.S. law changes so that we can no longer distinguish females from women with testes for any purpose, we risk not knowing the next Sonia Richards-Ross or the next Allison Felix. We risk losing the extraordinary value that comes from having women like Serena Williams, Ali Raceman, and Ibtihaj Muhammad in our lives and on the medal stand. If they bothered to compete, they would be relegated to participants in the game. One prominent trans activist has said that we shouldn't be concerned that the victories would belong to trans girls and women going forward, because what matters is their liberty to self-identify and their right to be treated equally throughout society. Others, including some in the Title IX advocacy community, have embraced this evolution, arguing that what we should care about is participation. These advocates are right to seek avenues for transgender inclusion, but listen carefully to the particular bargain they are willing to strike. In effect, it's that we don't need parity of competitive opportunity. They're wrong about this. Participation contributes to equality for females, but the real power of sport isn't in gym class. It's in teams, competitions, and victories. It's in the same numbers of athletic scholarships and of spots in finals and on podiums. It's in the fact that Brandi Chastain can win worlds, celebrate like the guys, and get a whole generation of little girls to play soccer because she did. It's in the fact that Simone Manuel can win Olympic gold in the 100-meter free with millions watching on primetime television, and from there can lead a generation of African-American kids to the pool who didn't believe that swimming was for them. I encourage you to consider revisions to H.R. 5 that provide protections for sexual orientation and gender identity that don't risk these invaluable goods and that are otherwise thoughtful about the circumstances in which sex still matters. Thank you.
Thank you, Ms. Contreras.
Thank you for taking the time to hear my family's story. 4.5 years ago, my 6-day-old daughter was denied medical services by our hand-picked pediatrician. This was after we made very strategic and intentional decisions to do everything in our power to avoid this very act of discrimination from happening. You see, about 7 years ago, my wife Krista and I were living in my small hometown located in West Michigan. After deciding we were ready to start a family, we made the hard decision to pack up our lives and relocate 230 miles to the metro Detroit area, hoping to ensure our future children would grow up in an accepting community free from discrimination. We ended up finding the perfect house located in one of the most LGBTQ-friendly towns, which has a good school district, close-knit community, and above all, it's safe. Not long after we purchased our home, we found out my wife was pregnant with our first child. We were elated. Doing what any good parents would do, we started to research pediatricians. We asked for help on social media forums and obtained referrals from people we knew. My wife and I both made sure to attend every interview with potential pediatricians, making it very clear this was a 2-helicopter mom family. After several interviews, the search was over. We had found a pediatrician that met all of our requirements. She was personable, energetic, listened to our concerns, was able to talk through her medical philosophy and explain things in a way we could understand, and she didn't seem to concern we were 2 moms. We left that meeting with her telling us just to call our office after the baby is born and set the appointment. Well, a few months later, our amazing baby girl, Bay Windsor Contreras, was born. We followed the doctor's orders, made our first appointment, and we were so excited for that appointment. As new parents, we were craving that reassurance that we were just doing everything right and our baby was healthy and happy. When we arrived at the office, they escorted us in our room. We waited for our doctor, excited to show her off. But when a different doctor walked in the room, she introduced herself and then started in with the appointment. Krista and I, confused, had to stop the doctor to ask, "I'm sorry, where's Dr. Roy?" She proceeded to tell us Dr. Roy would not be seeing us and she would be Bay's doctor today. When asked why, she stated Dr. Roy had prayed on it, and she decided she would not be able to take Bay on as a client. My stomach sank, my eyes filled with water, and the lump in my throat felt like a rock. I remember staring at my new baby who was now being examined by a doctor we had never met, and all I could think was, what have we done? How did we get here? We did everything within our power to avoid this very moment. We literally moved across state. We spent endless hours of research and interviews just to avoid this very situation. Yet here we were. It was our job to protect her, and there we were, only 6 days into the most important jobs of our lives, and we had already failed. While checking out, the receptionist asked if we wanted to make another appointment. We declined, and stated we would not be back, to which she told us she understood, showing us full well she knew exactly what was going on before we even did. It was a somber ride home from that appointment. Krista rode in the back seat with Bay as I drove home fighting back tears. Instead of leaving that appointment with reassurance, we were left with nothing but fear and more questions. My mind was racing with the question that still haunts me to this day. What's next? Will we be asked to leave a restaurant, not allowed to sign her up for a soccer team? Will we be denied access to the school of our choice? Or worse, are we going to be refused help by an EMT? The only silver lining in our story is that she was 6 days old rather than 6 years old. So we luckily didn't have to try to find the words to explain to her what had just happened in that moment. However, she's now at an age where she's starting to ask questions. We have to explain why mommy and mama are sometimes on TV or have to take trips like this one. She impresses me with her ability to comprehend the concept of equality. She often responds with questions such as, "Why, mama? It's okay to be different." Or what she said when I asked her if I should come here today. She said, "You have to go, mama, because you can help all families, not just ours, feel safe." When people ask us why we keep speaking up with the risk that comes with putting our family in the public eye, my wife and I know all too well, no amount of planning can avoid discrimination. We have to keep sharing our story to let people know this is happening to people like us and families like ours every day. And the only protection has to come from our government. We need our government to send the message that all Americans are equal. This is where you come in. We're calling on you to pass the Equality Act. Please help me show my daughter and my son that our family and all LGBTQ people have the right to feel safe in the communities they live. Thank you.
Thank you, Ms. Silas.
Good morning, Chairman Nadler, Ranking Member Collins, and esteemed members of the committee. Thank you for inviting me to testify before you today. My name is Tia Silas, and I'm the Vice President, Global Chief Diversity and Inclusion Officer for IBM. I am responsible for creating and implementing IBM's diversity and inclusion strategy in over 170 countries around the world, advocating for fairness and equality, which we believe to be core to 100 years of success. I am honored to speak at today's important hearing on the Equality Act to discuss IBM's long-standing and strong support for the legislation, as well as to provide the committee with an overview of IBM's proud history of inclusive LGBT+ policies. At the outset, I wish to highlight a March 7th, 2019 letter of support for the Equality Act signed by IBM's Chairman, President, and Chief Executive Officer, Ms. Ginny Rometty, in her capacity as Chairman of the Business Roundtable's Education and Workforce Committee, and on behalf of all Business Roundtable members, companies, and their 15 million employees. A copy of that letter has been submitted with my testimony. I'd like to provide the committee with several reasons why the Equality Act's affirmative non-discrimination protections for LGBT+ individuals across the areas of housing, public education, credit, public services and spaces, and jury service make good business and economic sense. IBM's core business objectives are to hire the best, most talented individuals, regardless of their gender identity, sexual orientation, religion, or other personal characteristics. Let me outline why. Diversity of talent ensures differentiated innovation. In order to remain one of the leading companies in the world, we seek to recruit, hire, retain the best talent anywhere, irrespective of any singular factor of a person's identity. We value a workforce that reflects the diversity of society so that we can create solutions that are both relevant and revolutionary. We don't want our employees and their families to be limited in where they can safely and comfortably live and work. Employees must live without fear of their personal safety and security, regardless of where they reside. Without affirmative protections, employees may feel forced to be on guard so as to not inadvertently reveal their LGBT+ status. This creates stress and distracts individuals from being productive. Like other companies, IBM's business location and investment decision-making process factors in discrimination-related legislation and policies. The United States already faces a shortage of qualified and experienced talent in key technology growth areas, such as artificial intelligence, blockchain, quantum computing, cybersecurity, healthcare, and so much more. It is in the best interest of the country to ensure that all talented individuals have equal opportunity and are able to pursue careers in these and other critical fields. The Equality Act tracks state-level statutes that have already proven successful. But at the same time, we are extremely concerned about the patchwork of non-comprehensive protections. The inconsistency and multiplicity of statutes, both positive and negative, begs for a federal minimum standard of basic protections that extend to all LGBT+ individuals nationwide. As IBM's Chief Diversity Officer, I am fortunate to design and implement many inclusive policies, collaboration tools, and benefits to support IBM's LGBT+ community, allies, and families. In my testimony, I articulate many proud moments in our history. However, in my time here today, I will highlight some of our current offerings. IBM offers transgender inclusive healthcare benefits. We have 52 LGBT+ employee resource and affinity groups around the world. We require all U.S. contractors to comply with non-discrimination standards. We have launched employee and general public training and certification programs about LGBT+ inclusivity. We sponsor an LGBT+ executive council, which includes leadership from a senior vice president who reports directly to IBM's chairman, signifying IBM's top executive support for inclusion. IBM believes that fostering inclusive work environments goes beyond employment practices and protections. That is why we strongly support the Equality Act and the extension of protections it proposes across so many critical areas of society. Our country's future economic success depends on it. Thank you again for the opportunity to testify before you today. I look forward to answering your questions.
Thank you, Professor Yoshino.
Chairman Nadler, Ranking Member Collins, and members of the committee, thank you for the opportunity to be with you here today. My name is Kenji Yoshino, and I am the Chief Justice Earl Warren Professor of Constitutional Law at New York University School of Law. This year marks the 50th year anniversary of the Stonewall riots, which inaugurated the modern LGBT rights movement. Fittingly, the Supreme Court just last term stated, quote, "Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. For that reason, the laws and the Constitution can, and in some instances must, protect them in the exercise of their civil rights." By passing the Equality Act, Congress will bring the nation closer to realizing that promise. I will summarize 6 points about the act that I have made in my written testimony. First, the act is necessary. Despite the extraordinary strides our society has made in the past few decades, LGBT individuals continue to face broad forms of social and economic discrimination. Recent studies have shown that 1 in 5 lesbian, bisexual, and gay individuals and about 1 in 3 transgender individuals reported unfair treatment in employment decisions. In some 29 states, no law explicitly prohibits discrimination in employment, housing, or public accommodations on the basis of sexual orientation or gender identity. Second, Congress is authorized to pass the Equality Act under both the Commerce Clause of the United States Constitution and Section 5 of the 14th Amendment. In 1964, the court found that Congress could use the commerce power to promulgate the landmark Civil Rights Act, which today's Equality Act both mirrors and extends. Further, Section 5 of the 14th Amendment gives Congress the power to pass legislation to ensure all Americans the equal protection of our laws, as the Equality Act seeks to do. Third, the Act represents an exemplary application of the principles of American federalism. More than 20 states have explicit laws against discrimination in employment and housing on the basis of sexual orientation or gender identity. As Justice Brandeis famously said, the states are laboratories of experimentation. We have seen these experiments succeed as millions of LGBT Americans have gained dignitary rights in their home states. Meanwhile, the risks that detractors threaten have not materialized. Studies have found no evidence that protecting transgender people from discrimination leads to any increase in safety incidents in gender-segregated bathrooms or locker rooms. Further, trans women athletes have not broadly displaced nor disadvantaged non-trans women and girls when allowed to compete in accordance with their gender identity. Fourth, a majority of federal circuit courts nationwide have already interpreted federal laws prohibiting sex discrimination to include discrimination based on gender identity and sexual orientation. By codifying this sound set of precedents, Congress would ensure that the applicability of federal law does not depend on where an American resides. Fifth, the Equality Act advances civil equality for LGBT individuals while respecting religious freedom. The claim that the Act compromises religious liberties ignores the existing exemptions in the civil rights laws that the Equality Act would amend, such as the exception the Fair Housing Act makes for religious organizations to prefer people of the same religion when selling or renting commercial space. This claim also scants the safeguards instilled in the Free Exercise Clause of the United States Constitution. As cases ranging from the Lukumu Babalu I case to the Masterpiece Cake Shop case demonstrate, any misapplication predicated on religious animus would swiftly falter. Sixth, the Act validly reaches conduct as well as status. Some have argued that sexual orientation and gender identity are distinguishable from protected classifications like race or sex because they are defined partly by conduct rather than by status alone. This distinction is unavailing. Civil rights protections in this nation have never been limited to status alone. Neither religious conduct nor pregnancy are immutable characteristics, yet both are protected under Title VII. I will close with how I introduced myself as the Chief Justice Earl Warren Professor of Constitutional Law. When that title was offered to me by my then dean, I rejected it. I reminded him that I was of Japanese descent and that, as Attorney General of California, Earl Warren superintended the internment of people of Japanese ancestry. In his wisdom, my dean responded that after he became Chief Justice of the United States Supreme Court, Earl Warren not only expressed regret for his role in the internment, but was the author of our nation's most honored civil rights opinions. What better title could I have than the name of someone who had traveled so far on issues of civil rights over the course of a single lifetime? So I now wear this title with pride, wondering in how many countries a racial minority could move so quickly from being outside the protection of the Constitution to holding a place of honor as a scholar and teacher of that hallowed document. I consider it a matter of grace that I can tell the same story in a different register. I am a gay man who was born the year of the Stonewall riots. Because of judicial and legislative decisions like the one you are asked to make today, I married my husband 10 years ago, and together we are raising a son and daughter. Despite all the forms of privilege we possess as a family, we still feel unsafe traveling to certain areas of this country. Even in our home state of New York, we have experienced acts of exclusion and bias. In those moments, I worry less about myself and more for my young children, as Dr. King did for his own 6-year-old daughter when she faced discrimination in a public accommodation. I fear seeing the ominous clouds of inferiority begin to form in their little mental skies. So it is no small matter you consider today. In the last half-century, I've walked 2 versions of the American dream. That journey has led me to believe that the experience of discrimination on the basis of race on the one hand, and discrimination on the basis of sexual orientation or gender identity on the other are not entirely different. And it has led me to believe the dignity the law can bestow in welcoming us into the light of the public sphere is entirely the same. Thank you.
Thank you. I thank the witnesses. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes, and I have 3 questions for Ms. Chandy. Ms. Beck objects to the addition of gender identity as a protected characteristic in our civil rights laws because she believes that treating someone as if they are a member of the opposite sex is not a civil right. What's your response to that?
Yes, I mean, listening to that testimony, it seems like that particular witness does not believe that transgender people exist. And personally, I've sort of worked in volunteer capacity over the last 25 years with LGBTQ organizations. And I just want to say, like, no one up here are doctors or scientists, so we are talking about our experience with people and how that fits into the law for today. And so I've met numerous transgender individuals who are trans women and girls, are women and girls. And in terms of the biology piece, biology is made up by so many different things, as I understand it, not just external sex organs. There are hormones, there are internal things. And so all of these things make up a person. And so transgender women and girls are women and girls, transgender boys and men are boys and men, as we've heard. And so to sort of have someone basically say that doesn't exist, and then to say that people will go so far as to make up an entire identity, change their pronouns, maybe engage in medical treatment or not, just simply to invade sex-segregated spaces or participate in sports is so outlandish. It's so far-fetched when you think about the weight and seriousness that someone goes through before deciding that they need to be, presenting in a gender-affirming gender identity. And so it just sort of, I hear it as offensive because it's sort of it sounds to me like someone saying that a particular identity doesn't exist. But I could also address the point about sex stereotyping. That is the very theory that the Supreme Court has used to cover both sexual orientation and gender identity. The Supreme Court has said how you present yourself, what sort of whether you present in a feminine or masculine way, all of those sorts of things are protected, and you cannot discriminate based on those. And that is the theory that has led us to saying sexual orientation and gender identity are all part of sex discrimination. And that's not allowed to discriminate on any of those characteristics.
Thank you. In her written testimony, Ms. Beck lists a number of potential scenarios that could arise if Congress were to include protections against gender identity-based discrimination in the Equality Act, including, quote, men will dominate women's sports, and that girls will stay home from school when they have their periods to avoid harassment by boys in mixed-sex toilets. What is your response?
Yeah, there's no research to support the claim that allowing trans athletes to play on teams that fit their gender identity will create a competitive imbalance. Trans children display the same variation in size, strength, and athletic ability as other youth. And there's no reported instances of a boy pretending to be transgender or presenting as a girl to fraudulently join a sports team. There's just no examples of this happening. And for this to be raised as the issue today, we are an organization who care about women in sports. We can talk about women in sports, unequal pay, how women coaches are treated, resources given to women in sports. We can spend a lot of time talking about women in sports. The quote-unquote problem of transgender inclusion in sports is not the issue that it's being raised.
Thank you. I have one more question on the same topic. Professor Coleman testifies that female athletes, quote, know that segregation on the basis of sex or at least of sex-linked traits is necessary to achieve equality in this space. And he also testifies, Professor Coleman. She testifies that because those born male are exposed to much higher levels of testosterone, they enjoy physical advantages in athletic performance, and that is that not recognizing this difference will hinder women's opportunities in sports. Your response to those?
I would just say in half of the country, we have state and local laws that protect on the basis of gender, sexual orientation, or gender identity. And as Professor Yoshino displayed or described, this has been going on in half of the country, and it's not as if sports has been women's sports has been overcome with transgender athletes winning every race. Even in the example that was given in Connecticut, which is the only one I'm hearing, those people went on to the nationals and one didn't participate and one came in like 30th or 31st. So this idea that transgender inclusion is going to mean that transgender individuals are going to win in all of the sports is simply not true. We've heard no data to say that that's true, and these are just fears and myths and stereotypes, which is not a way that we can make law.
And finally, given that many courts have interpreted Title VII and other civil rights statutes to already prohibit discrimination on the basis of sexual orientation or gender identity, why do we need to amend existing statutes to provide such protection?
Okay, so right now, the circuit courts are sort of deciding, and there's been a growing consensus among federal courts that the existing prohibition on sex discrimination also prohibits discrimination based on sexual orientation or gender identity. But that depends on the court that's looking at it. There's also some circuits that haven't gone in that way. And so it is not fair that whether or not you have rights not to be discriminated against based on sexual orientation or gender identity cannot depend on the state you live in, the location, or the circuit. That is not a fair way to have civil rights protections. These protections need to be firmly established in the legislation so that all judges need to follow it, all circuits need to follow it, and that everyone in the country can have this protection.
Thank you. I take it you mean should not cannot. My time has expired. The gentleman from Georgia, the ranking member, Mr. Collins, is recognized.
Thank you, Mr. Chairman. H.R. 5, continuing on to require under federal law that all entities receiving federal financial assistance, including K through 12 schools, colleges, hospitals, and recognize whatever self-professed gender identity an adolescent might profess. In the audience today are several parents representing the Kelsey Coalition. These are parents of transgender identifying children who have been harmed by gender identity medical practices. Their stories are not reported in the press. They have been denied meetings with their representatives, and they are here today to make sure that this committee will seriously consider the disastrous impact of including gender identity in the Equality Act, under which doctors will be required to administer testosterone to young girls on demand. They will be required to block the puberty of young boys based on the feelings of gender confusion. And this is already happening, and putting gender identity into federal law will turn these unsound medical practices into federal mandate. The opposition to this bill is both deep and wide in both Republican and Democrat. Men and women, mothers and fathers from all sides of the political spectrums and no side at all. I just received a letter this morning from a Georgia mom deeply concerned with what is happening with girls' sports and its effect on daughters and girls everywhere. And I'd like to ask that to be submitted for the record.
Without objection.
But opposition to this bill also consists of many people who are scared to express their views, and so we on our side are going to use some of our question time to give voice to those who might otherwise remain voiceless in the face of the injustice that would be imposed by this legislation. To that end, I will begin my questioning by reading parts of the peer-reviewed study by Dr. Lisa Lippman entitled Parents' Reports of Adolescents and Young Adults Perceived to Show Signs of Rapid Onset Gender Dysphoria, which shows how the transgender ideology is propagated in part by social media and aimed at vulnerable children. H.R. 5, if enacted, would codify an internet phenomenon into federal law. H.R. 5 would make it illegal for well-meaning parents and doctors to protect children from rash judgments that are part of childhood, even more so in the era of smartphones and social media obsession. The quote following is from Dr. Lisa Lippman's article. Dr. Lippman found that none of the AYAs, adolescents and young adults, described in this study would have met diagnostic criteria for gender dysphoria in childhood. In fact, the vast majority, 80.4%, had zero indicators from the DSM-5 distinct diagnostic criteria for childhood gender dysphoria, with 12.2% possessing one indicator, 3.5% with two indicators, and 2.4% with three indicators. Adolescents and young adults had received online advice, including that if their parents were reluctant to take them for hormones, that they should use the suicide narrative, telling the parents that there is a high rate of suicide of transgender teens. To convince them, 20.7%. and that is acceptable to lie or withhold information about one's medical or psychological history from doctors or therapists in order to get hormones and get hormones faster, 17.5%. There is a lot of concern, as I stated in my opening statement. There is love and compassion for all folks who are going through different stages, but this bill has real consequences and real concerns. And Professor Coleman, as a member of Congress, I'm used to being discussed in third persons about what I've said and not said, and my chairman and I, we talk about each other a lot in different ways in what we've said, but your testimony has actually been brought up, and I would like for you to be able to respond also to what was said earlier, discussing the sports aspect and some of these differences that we have seen that's not isolated in this, and we'd like for you to comment on that.
Thank you. So I understand that sport is really important in consideration of this bill, but of course it's more broadly, it covers a lot of things more broadly, and I want to make clear again that that my position is narrow and concerns only sport. And you can do with that what you'd like. A couple of responses. Again, Professor Yoshino mentioned that transgender girls and women haven't yet broadly displaced girls and women in sport, and that's absolutely right. But also, this is just the beginning of a period of time in various states where trans kids are coming out as trans and are being welcomed and included for their authentic selves. And so the question is, what will happen if this trend continues and identification into girls and women's sport comes to be based on gender identity rather than biology, or in addition to biology on an equal basis. In the Olympic movement, we've seen the effects of this issue in the last period, where the Court of Arbitration for Sport lifted the requirements of testosterone reduction for intersex and trans women, and for example, the Olympic podium in the women's 800 meters likely was comprised entirely of biological males in the last Olympic championships. And that is, we're talking 3 people out of hundreds of girls and women. I'll just add, with respect to the national championships in indoor track recently, the high school college national championships, only one of the 2 girls from Connecticut was able to compete, and the girl who was able to compete had satisfied the National Scholastic Athletic Foundation policy of dropping her T levels for over a year to within the women's range, the girls and women's range.
All right, well, thank you. And again, I appreciate everyone who has come here today for your witness. We may disagree on certain things, but also not everything is simply solved by an HR number. And these are questions that need to be addressed and need to be talked about, but I think the concerns both sides relate here is something that we need to discuss, and I appreciate the chairman having it, and we'll continue on, and now that I yield back.
I thank the gentleman, the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman. Like so many other Americans, LGBTQ Americans have had their rights eroded since the administration took power, from removing LGBTQ issues from federal data collection surveys to the ban on transgender individuals from serving in the military, just to name a few. The first few years of the presidency had our country taking several steps backwards. We have taken this step with the Equality Act to stop stepping backwards, but to step forward. And I'm a proud original co-sponsor of this bill as a consequence. Everyone, regardless of their sexual orientation, should be afforded the same protections provided under the Civil Rights Act and other civil rights bills, and the Equality Act does ensure that that is the case. You know, I've listened to the testimony, and all of you said interesting things, and I appreciate that you were here. But Reverend Wiley, I was so moved listening to your testimony and thinking back to your days in the segregated South. And, you know, we have many challenges remaining, but we have made some progress. We should celebrate the successes in addition to bemoaning the challenges that remain. But I'm particularly struck that you are here as a man of faith, and many opponents I'm not suggesting here on the days today, but in our country of LGBTQ equality, claim that somehow that equality is at odds with religious freedom and with people of faith, and yet here you are, a faith leader, testifying in support of this bill. Why, as one who's dedicated himself to religious life your entire life, do you support LGBTQ equality? How do you reconcile your faith, your belief, with those who oppose it for religious reasons?
Thank you for the question. I grew up as the son of a Baptist minister. My uncles, a couple of uncles were ministers. I have an aunt who was a minister, cousins, my brother. So I've been surrounded by the church all my life. And I'm thankful that my parents not only taught me the Bible, but they also lived what they believed to be the principal concept of the Bible. That included justice, equality, liberty, compassion, and those are the kinds of things that were instilled in me. And also the need to stand up for what we believe is right. My father assisted Dr. King on many occasions in the civil rights movement. And so I grew up believing that it was part of my responsibility as a minister, not just to stand in the pulpit and preach on Sunday mornings, but also to be active in the community and in the nation and the world in an active way to challenge any kind of issue that would bring any kind of injustice to people. And I also was taught to respect and appreciate all of God's creation, that God was a God of love and a God of forgiveness and a God of saying that everybody is welcome into God's house. So I am sometimes amazed at how the church is not more active in struggles like this. Martin Luther King Jr., when he was sitting in the Birmingham jail and wrote the letter from that jail, he was concerned that some of the ministers in that town were saying he was going too fast. He needed to wait. He needed to slow down and be more gradual. But he says that he could not wait because injustice delayed is injustice denied. And so that's where I come from, and not only was I was I involved in the struggle for racial justice, but as I studied, and I studied with theologians who helped me to understand that none of us are free until all of us are free.
Thank you very much, Reverend. My time has expired, but your words are inspiring to us all. Thank you very much.
Thank you. I now recognize the gentleman from Ohio, Mr. Shabbat.
Thank you, Mr. Chairman, and thank you to all the witnesses for providing insight to members on both sides of the aisle here, whether you're for or against H.R. 5. As well as being a member of this committee, I happen to be the ranking member of the House Small Business Committee, which is the lead Republican on that committee. In the last two Congresses, I was the chairman of that committee. And in that capacity, we get to hear from small businesses all over the country and about how laws that we pass here impact them on a daily basis. And I would note that America's small businesses provide about 70% of the new jobs created in America nowadays. With respect to H.R. 5, small businesses, particularly small business owners who have common religious beliefs, many of whom are women, have shared their concerns about H.R. 5 with me and other members. For example, and we've already seen this in athletics, where physical men now in some cases have to compete with women, and we've heard testimony on both sides of that. And it doesn't seem to be fair to a lot of people that men who identify as women are competing with women. Similarly, it doesn't seem fair for men who identify as a woman to be able to take advantage of certain government contracts, because doing so allows them to utilize the women-owned small business federal contracting program, for example, which is designed to provide greater access to federal contracting opportunities for women-owned small businesses. One of the requirements to be certified in that particular program is to be 51% owned and controlled by one or more women. This program gives contracting officers a statutory goal of providing at least 5% of federal contracting dollars to women-owned firms, and adopting H.R. 5 could mean that this program and others like it, designed to level the playing field for women in business, could be jeopardized. So that's certainly, I think, something to be considered. It could also mean that small business owners would have to absorb the cost of providing health care if one of their employees wanted to undergo elective procedures that were covered under H.R. 5, the bill that we're considering today. This could be very costly for small business owners who are already facing rising health care costs under the Affordable Care Act or Obamacare, whichever terminology one prefers. Forcing them to provide pharmaceutical and other types of health care for these sorts of procedures because someone identified as a person of the opposite sex could, no doubt, exacerbate the already high costs to small businesses. So overall, while H.R. 5 says it is intended to provide equality for all, it, in many people's views, does anything but, and goes beyond creating a level playing field to once again making it easier for men who identify as women to take advantage of programs that are actually designed to do that. So that's something to be considered. And then finally, there was a report, Dr. Littman study, that I think a number of us have had access to, and I wanted to, this is a different topic, but there are online instructions about lying to parents and physicians under this. And these are a couple of things that it said, and these are quotes from some of these young people. Find out what they want to hear if they're going to give you T, which apparently stands for testosterone, and then tell them just that. It's about getting treatment, not about being true to those around you. It's not their business, and a lot of time doctors will screw stuff up for you. Another one said, get a story ready in your head, and as suggested, keep the lie to a minimum, and only for stuff that can't be verified, like how you were feeling, but was too afraid to tell anyone, including your family. From another one, I'd also look up the DSM, which is Diagnostic and Statistical Manual, by the way, for the diagnostic criteria for transgender, and make sure your story fits it, assuming your psych follows it. Another correspondent offered, quote, he is rewriting his personal history to suit his new narrative. And another respondent said, our son has completely made up his childhood to include only girlfriends and dressing up in girls' clothes and playing with dolls, et cetera. This is not the same childhood we have seen as parents. And then finally, another parent said, I overheard my son boasting on the phone to his older brother that the doc swallowed everything I said, hook, line, and sinker, easiest thing I ever did, unquote, and I yield back.
Thank the gentleman. The gentleman from Georgia, Mr. Johnson, is recognized.
Thank you, Mr. Chairman. Good morning, and thank you all for being here today. Civil protections should ensure that no one can be discriminated against in their housing, their employment, and their public accommodations. Would you agree with that, Professor Coleman?
Yes, sir, I do.
And do you agree with that, Ms. Beck?
Yes.
And so you both seem to be more in line with discriminating in the area of athletics, in the area of women's athletics. Is that correct, Dr. Coleman? Professor Coleman?
That's what I'm here to testify about.
And Ms. Beck, you also?
I believe sex is the basis upon which sports should be segregated.
Now, is it true that there are some women who have high levels of testosterone and then some with lower levels of testosterone?
So if I can point you to.
Well, I mean,
Sure.
I'm just asking as in general.
Some
Women, traditional women, if you will,
biological females' T levels do not overlap with biological male T levels. There's quite a gap, no overlap between the two ranges.
so you are in favor of kind of discriminating in the field of athletics based on testosterone levels?
We have always done that. Sport has always done that.
All right. Now,
That's the reason women's sport exists, is because of testosterone levels.
Ms. Chandy, what is your position on that? On that distinction insofar as it would create an ability to legally discriminate against someone?
Yeah, I mean, the Equality Act would ensure that LGBTQ students, including women and girls who are LGBTQ, have the same opportunity to participate as their peers. We've heard about the benefits of sports, particularly for students who may be experiencing self-esteem or other concerns. It can be incredibly important. And so the key for most of the people playing in sports is for inclusion and participation at those levels. And states, schools, and athletic associations across the country have found for many years that equal participation for LGBTQ students, including ones who are transgender, does not harm women and girls sports in any way. I also want to say that under similar state laws, schools and athletic associations have developed approaches that place primary focus on ensuring equal opportunity for participation for transgender athletes while taking account of the different contexts for ages and levels of competition. And so there are rules that govern these areas where experts can figure out how to allow transgender students to participate equally and without facing discrimination. And so these sort of discussions and rules are already in place in half of our country. And I was so relieved to hear Professor Coleman say, this is actually not a problem now. This is a hypothetical problem. And meanwhile, people are being excluded. And we want people to not have a place on the team for some hypothetical problem that we cannot even, there's no evidence of it. And so we cannot create law based on that.
Thank you, Professor Yoshino. Has this issue of testosterone levels and sports been an issue that you have formed an opinion about?
I do have an opinion, basically.
Touch your microphone.
I defer to Ms. Chandy, who has a deeper expertise on this issue than I, but I do have an opinion based on the mere empirical evidence that's been adduced. We opened with Ranking Member Collins offering up the example of the two individuals in Connecticut who placed first and second in a particular athletic meet. Ms. Chandy responded by saying they went on to nationals. One didn't participate, the other placed 30th. Then I understood Ranking Member Collins to follow up on that and to say to Professor Coleman, I understand that this is not, a single incident, and this is actually a much broader phenomenon. And I heard Professor Coleman agree with my testimony to say that this is not a broad phenomenon, that these are isolated incidents, but that in the future we might expect more. And my only response to that is, again, the federalism point, which is that we have had decades of experience since the 1970s of women participating, trans women participating in women's leagues, right? And they have not dominated. And it just strains credulity, Representative, to think that an individual who is undergoing such a deeply personal transformation as to transition away from the gender assigned to them at birth would do so opportunistically simply because they wanted a gold medal in some track meet. This is not what gender identity is about, and this is not what the AMA or the American Psychological Association or the American Psychiatric Association say that it is about. This is a civil rights issue. This is not about individuals opportunistically trying to take advantage of particular entitlements or benefits that are accorded to women, whether that be in sports, whether that be in small business. It's a deeply, deeply personal issue of identity formation that occurs, as many physicians say, at a very early level. And one thing that I really appreciate both sides of the aisle being concerned about is our youth and our children. And I'm glad to hear that even opponents of this bill articulate deep compassion for the children who are affected by gender identity disorder. I will point out that in the name of that compassion, I think it's useful to point out that the suicide rate among individuals who are transgender is 40%, right? 40% of individuals had attempted suicide in their lifetime, which is nearly 9 times the attempted suicide rate in the overall population. That obviously applies to youth as well.
The gentleman's time is...
Thank you.
Mr. Chairman, may I have a unanimous consent request? Mr. Chairman, I ask unanimous consent in light of this line of questioning that this statement of women's rights and gender justice organizations in support of full and equal access to participation in athletics for transgender people be made a part of the record. It is signed by a number of organizations, including the American Association of University Women, Legal Voice, the National Women's Law Center, the National Women's Political Caucus, Women Leaders in College Sports, the Women's Sports Foundation, and many, many others. I'd ask that be part of the record.
That objection, the document will be made part of the record. The gentleman from Texas, Mr. Gohmert, is recognized.
Thank you, Mr. Chairman. Ms. Coleman, you have a response to the last answer?
Yes, please. So trans women and trans girls are participating in sport, and most of them this is just a factual point, most of them actually have dropped their T levels. In fact, part of transitioning, as I think everyone knows here, I do a lot of work with trans kids, including in the in the medicine area. And one of the things that trans girls would like to do is to drop their T levels into the female range as part of becoming their authentic selves. And when they do this and they compete, it's not at all a problem. And so just to be clear, at least my position is not that trans kids should be excluded from sport. It is simply that inclusion based on biology or biological traits, sex-linked traits, makes sense, because otherwise, in fact, and this is not a hypothetical, in fact, it will be the end of girls and women's only sport if we make simply gender identity the basis for eligibility for girls.
Right,
and
you'll
women's
have
sport.
men's sports and you'll have co-ed sports. And that, you were one of 2 girls to get a track scholarship to Villanova in 1978, thanks to Title IX. And the point has been made, and I can see your facial expressions, Professor Coleman, with a comment that there's no evidence of problem with men competing. But there is no question that problem will continue to rise, and nothing more dramatic than this diagram you have, each one of these points representing an athlete, and the 3 red dots that are lost in the middle representing 3 Olympic winners in the 400 meters, and yet when they're compared with just the performances in the single year of 2017 of men, as you say, it shows that even at the women's best, the women would lose to literally thousands of boys and men, including to thousands who would be considered second tier in the men's category. And I think that we consider laws to say something is equal, like testosterone. The testimony's already indicated, it's clear in the medical literature. It does make a difference. And as you say in your testimony, I thought it was pretty clear, but scientists agree that males and females are materially different with respect to the main physical attributes that contribute to athletic performance. It is true, but to see that graph you got, that demonstration, anybody here that seriously thinks that there are men who would not like to have Professor Coleman's scholarship and could get it, apparently there are thousands that could have beat you if they're guys that say, look, I feel like I am a woman, and let's be fair here too. If we're going to say, as this law does, the Olympic Committee and every other sport is going to have to eliminate the testosterone level requirement. That's going to have to go, because the presence of that rule makes very clear that there is not equality in sports, and that's why that rule was put in place, because it was so unfair to the women. And you point out in your testimony, I mean, viva la difference, but women are biologically able to carry children, most, and men are not. There is a difference, and having my own experience in the area of felony judgeship, prosecution, I think about all the psychiatric testimony I've heard about women who they seem to have more post-traumatic stress disorder from sexual assault, and yet we're going to force them to have men in confined spaces, in shelters where they're seeking a refuge away from men inflicting violence on them. And because we're going to stand up here and say, well, it's just too bad, we're going to force men to be into your spaces and you're going to have to like it, I think is a war on women that should not be allowed. We need to make consideration for what's going on, and I would ask unanimous consent. Ms. Jandy, you talk about evidence. This is one of the best, most thorough reports. The New Atlantis, the Journal of Technology Society, had asked unanimous consent that this special report on sexuality and gender be admitted as part of the record.
Without objection.
The head of Johns Hopkins, the first hospital in America to do sex change surgery, Dr. Paul McHugh, his article in the Wall Street Journal dated May 13, 2016.
Without objection.
And also the transgender individual that had the surgery, Walt Heyer's article in the Federalist from January 29, 2019. I'd ask those be made.
Without objection, the documents will be admitted into the record. The time of the gentleman has expired. I would ask unanimous consent that the following documents be inserted into the record. A statement from the ACLU in support of H.R. 5, a statement from Todd Brower of the UCLA School of Law in support of H.R. 5, a letter from Nancy Kaufman of the National Council of Jewish Women in support of H.R. 5, a letter from Business Roundtable in support of the Equality Act, federal policy recommendations regarding how the criminal justice system affects the LGBTQ community from the organization Black and Pink, and a letter of support from the American Bar Association. And without objection, I will grant my motion to admit these documents. I now recognize the gentleman from Florida, Mr. Deutsch.
Thank you, Chairman Adler. Thanks for holding this hearing. Thanks to Representative Cicilline for introducing H.R. 5. I am proud to stand with the LGBT community and with an ever-increasing majority of Americans in support of full equality and truly equal protection for all. I think we can all agree that the mainstream view of LGBT has moved forward at a rapid pace in recent years. We still have a long way to go for full equality, and the Equality Act is an important next step. As I realized back when I was in the Florida State Senate, on these issues and so many others, legislative progress is tied to personal experience. When I introduced the Employment Non-Discrimination Act in Florida, it didn't include protections for trans people because we thought, maybe we should just take what we can get. We'll make a little bit of an advancement, and that'll be a dramatic step forward. And thanks to the thoughtful and passionate advocacy of Equality Florida and so many other activists that I've become privileged to know and become friends with, I came to understand how important it was to include trans rights, and what I learned then and what we are reminded of today, that equality means equality, and we can't have full equality if we leave people behind. That's what we're reminded of at this hearing today. So I'm a proud and outspoken ally of the LGBT community and the trans community especially, and I want to thank the panel for being here. I want to thank Carter and Jamie, Mr. Brown and Ms. Contreras. I want to thank you both for coming here today to share your stories. It can be hard to open your lives to the microscope of this hearing, but I think having members hear about your experiences with discrimination is a critical step to help move all of us forward. What struck me about both of your experiences is that you were both doing everything right. Mr. Brown, you invested in yourself. You worked hard to make a better life for yourself and your family. The thought that it could all disappear by the simple disclosure of your identity as a trans man is repellent, but it is sadly not surprising. Ms. Contreras, beyond the denial of care that you ultimately experienced, you and your wife wanted to take on the burden of being discriminated against in advance to shield your daughter from having to experience it herself, when in a fair world, all three of you would be protected. Both of your cases get to the heart of why the Equality Act is necessary. Yes, some states have laws explicitly protecting people from these kinds of discrimination, but fewer than half. So we can either accept that fewer than half of Americans benefit from equal treatment, or we can move forward with the Equality Act. That's what today is about. Now, I'd just like to say a couple words about some of what I've heard here today, and the gentleman from Texas's comments just before especially. I'm grateful to the trans community for something that I never thought I would be grateful for, and that is that there is now an interest on the other side of the aisle on women's athletics that has never existed in this House before. So I'm thankful for your helping to elevate the issue of full participation in women's athletics. Thank you for helping to accomplish that. I was struck.
Will the gentleman yield?
I will in one moment, because I'm going to say one more thing about something else you said. I also would acknowledge that it is frankly rich for some of my members on the other side of the aisle who come to this committee literally every single time we meet since I've been in Congress, doing everything they can to limit the ability of women to make their own choices about their own bodies, to talk about a war on women. That is absolutely rich, but I would be glad to yield to Mr. Gomer.
As a father of 3 girls who absolutely loved seeing them, helping them, coaching them, I've been a fan of women's sports for a long time.
Appreciate them. I appreciate that. Ms. Chandy, let me actually just give you the opportunity to respond to some of what we've heard just over the past 15 minutes or so.
You took my main point, which is I'm so excited to have a discussion about women's rights. We're talking about women's safety. In the Me Too moment, we have spent a considerable amount of work connecting people with lawyers to fight back about sexual harassment in the workplace, in the schools, and healthcare, and across all of these contexts. And women's safety and rights is at the utmost, at top of our mind as a National Women's Rights Law Center. And so in that context, I want to say that transgender students and individuals are at a higher risk of sexual violence than cisgender women, and we need to protect all of us and be in a collective struggle against sex discrimination and sexual assault wherever it happens. If there is an incident of assault, whether it be in a shelter, a prison, or anywhere else, it must be investigated and dealt with. And we are very firm about that. But we do not create policy about myths and stereotypes. And that is what I'm hearing here today, is that, based on individual instances of harassment or assault, they must be addressed. But that is not a reason to exclude transgender individuals from this bill. And you can never do that in the name of women's rights. And that's what I'm hearing here. And thank you for allowing me a chance to respond.
Mr. Chairman, if I could have 10 seconds, I appreciate it. Professor Yoshino, I also just wanted to take a moment to thank you for your comments at the start of this hearing and sharing your very powerful story, your personal story, the impact that 2 moments of our history have had on you, and how much of an honor it is for us to have you here with us today. So thanks, Mr. Chairman. I yield back.
I now recognize the gentleman from Florida, Mr. Gates.
Thank you, Mr. Chairman. For dozens of days, my Republican colleagues have gone to the floor of the House seeking a vote on the Born Alive Act so that human beings are not slaughtered and murdered after their birth. A number of those human beings are women. And so we will accept no lecture
Would the gentleman
from the
yield for a
left
second?
on that
Would the gentleman yield
subject.
for a
I'm
second?
gonna no, since the majority has taken in excess of their
I'll
time, I'd like to take all of my time, and I do not yield my time.
I'll grant you an extra minute.
Well, very well, then you can take it at the end of my remarks, then, Mr. Chairman. I want to support this legislation, and in the broadest sense, I do. I believe that individuals in our country should not face discrimination for their sex or their gender or their sexual orientation or if their gender identity. Our country is an inclusive place, and bigotry and prejudice and discrimination don't belong here. I very much want to support the legislation, but I can't, because the legislation would only nominally protect certain individuals while causing tremendous harm to others. First off, the legislation has a drafting problem, partly because H.R. 5 does not define gender identity well, and I'll read directly from the legislation. It says, the term gender identity means the gender-related identity, appearance, mannerisms, or other gender-related characteristics of an individual, regardless of the individual's designated sex at birth. And then only a few lines later, the bill says the term sex includes sexual orientation or gender identity. So gender identity is defined as a concept distinct from sex, but at the same time, the term sex is defined in part by gender identity. In the last Congress and in this Congress, we've passed legislation for the advancement of women, improving women's access to STEM education and careers. We've passed bills to increase the number of women-owned businesses, to help female entrepreneurs, and more. What happens when sex is defined as gender identity and gender identity is terribly vague? Will all sex-based distinctions be erased? That may sound like something my colleagues on the other side of the aisle would cheer, but thinking more broadly, would grants for female-led businesses or programs for women in STEM fields suddenly be open to all persons, whether they believe or not that they identify as a woman? I strongly support the rights of transgender individuals. I will not denigrate or deny their existence or their struggles, but I am concerned about the potential of bad actors who would exploit the provisions of this law for their own gain. Consider this possibility if President Trump were to say, I am now the first female president. Who would celebrate that? Would those who support the legislation think that's a good thing, or would they be dismayed? Bad actors have already weaponized some ostensible equality laws for their own benefit. Stephen Wood was convicted of serial sexual assault and was in prison. He then announced that he identified as Karen, a woman, and was transferred to an all-female facility where he promptly sexually abused female inmates. Recently, a musician and weightlifter who identified as Zuby briefly claimed identity as a woman, during which time he broke the woman's world record deadlift and then promptly went back to identifying as a man. These are isolated instances, to be sure, and I am most emphatically not saying that a majority of transgender individuals are using their gender identity to exploit the process, but I am saying that these cases do exist, and the legislation before us would expand and exacerbate those problematic loopholes. Faith-based businesses, religious institutions, and religious groups would find their rights greatly jeopardized by the legislation, as it explicitly prevents claims from being filed under the Religious Freedom Restoration Act. Consider the chairman's own words on the passage of that bill. He said, "What has made the American experiment work, what has saved us from the poisonous hatreds that are consuming other nations, has been a tolerance and a respect for diversity enshrined in the freedom of religion clauses of our Bill of Rights." It was no accident that the framers of our Bill of Rights chose to place the free exercise of religion first among our fundamental freedoms. The House should do no less, end quote. Yet this legislation significantly and overtly undermines religious freedom, and it's not something worth celebrating because it will harm people and communities of faith across our nation. Again, I support protecting individuals from discrimination based on their sexual orientation or gender identity, but this legislation creates more problems than it solves. It will chill freedom of speech. It will harm religious liberty. It will undermine women's rights, and I wish I could support it, but I can't. And I wanted to yield my remaining 20 seconds to Ms. Beck because I found your advice very instructive about a path forward that would accommodate our desire for greater equality without falling into some of the traps I've identified.
Thank you, and I'd like to dispel some of the logical fallacies that were stated today. No one is saying that people don't exist. How can we tell if someone's lying about identifying as transgender? If Karen White was a woman, then he would have belonged in the women's prison, but we know that he was lying. There's no way to tell if someone's lying about being transgender because there's no evidence. And I'd like to go back to what Ms. Chandy said. If there's no evidence, we cannot legislate. There is no evidence of a gender identity. It's not a material reality at all. There is also the myth of assault being higher for people who identify as transgender, but according to GLAAD in 2015, there were 20 people killed. The rate of murder for transgender identified individuals is 1.5 per 100,000. That's lower than the murder rates of both men and women. So this data shows that people who self-identify as transgender are murdered at a lower rate than general population. I'd also like to say that, where else was it?
Time of the gentleman has expired, is well expired. The gentleman from New York, Mr. Jeffries.
Thank you, Chairman Nadler. And let me also thank my good friend David Cicilline for his tremendous leadership on the Equality Act. I have great respect for my friend from the state of Florida, but the reality of the situation is that many of my colleagues voted against the Paycheck Fairness Act. Many of my colleagues voted against equal pay for equal work, notwithstanding the fact that women are paid approximately 80% of what men are paid for doing the same job. Many of my colleagues on this Judiciary Committee voted against the Violence Against Women's Act. So we do find it strange that you want to come here and lecture us about women's rights. Mrs. Chandy, you have 20 years of experience in civil rights law and are a member of the LGBT community, is that correct?
Yes, that's correct.
And LGBTQ Americans make up approximately 4.5% of the population, is that right?
Right.
And that's about 14 million people, is that correct?
Yes.
But there's no federal legal standard that guarantees 14 million Americans rights and protections under our civil rights law, is that right?
That is correct.
So that means that there are still places in the United States of America where someone can be fired because of their gender identity or sexual orientation, is that right?
That is right. There's federal law that's evolving, but it is not a guarantee, and there's no clear or explicit protections in federal law to protect against sexual orientation or gender identity-based discrimination.
And are there still places in the United States where someone can be evicted because of their gender identity or sexual orientation?
That is correct.
And still places in the United States of America where someone can be denied a loan because of their gender identity or sexual orientation?
That is correct. I am giving just the caveat that there are federal protections evolving, but those are not guaranteed, and so it's sort of a guess, and so we need the clear federal protections.
Okay, and approximately 50% of LGBTQ Americans live in 30 states that lack statewide legal non-discrimination protections, is that correct?
Right.
Is that one of the reasons why it's important to have a federal standard?
That's right.
Okay, nearly 2/3 of LGBTQ Americans report having experienced discrimination in their personal lives, is that true?
Right, yes.
And do discriminatory laws and practices have a negative impact on our economy?
Well, of course, I mean, you're not getting jobs, not getting housing, you're not able to purchase things. I mean, the areas of protection that we're looking for today impact all areas of our lives.
Mrs. Silas, several hundred companies, including your own, support a federal non-discrimination standard for LGBTQ Americans, like the one included in the Equality Act, is that right?
Correct.
And can you explain why you, as a business person, support it?
Yeah, there are a number of reasons. So one, I stated earlier that enduring 100 years as a prominent American company, has been grounded in really our belief around fairness and equality. And this isn't the first issue we've advocated for, and it probably certainly won't be the last. But we think it's an enduring characteristic of an American company. The second is the survival of any corporation is about skills and adequate access to those skills. And we believe that access to skill means that we need to ensure that our employees are in environments that will protect them and their families, and that doesn't become a distraction to the productivity and the contribution that they can have to American innovation. And then lastly, what we find problematic is certainly the patchwork of legislation. So thinking about a brand such as IBM and how we operate, it certainly isn't within state lines, and that we can't just ensure access to skills and protections of employees based on singular state legislations, but there really needs to be a federal minimum standard so that our employees can operate and run our businesses broadly.
In terms of that patchwork, one of the things that my free enterprise colleagues on the other side of the aisle often lecture us about is the notion that we need certainty in the business environment. How can you have certainty when there's a patchwork of legislation in terms of what states do or do not do? And last question, my time is expiring. Am I correct that your company actually bases business decisions on whether a state has a non-discrimination protective statute or not?
That is 100% correct, and that's correct in this context and dates as early as the 1950s when we declared, even in prior to the Civil Rights Act, that we would be making decisions around where we base our employees based on segregation policy at that time, and the idea that we would not comply with that. So it's not new to us, and it certainly is the case today.
Thank you. Not only is the Equality Act, in our view, pro-American, it's also pro-business. I yield back.
Thank the gentleman for yielding. The gentleman from Colorado, Mr. Buck.
Thank you, Mr. Chairman. Ms. Contreras, I want to ask you a quick question. You said in your testimony that you had chosen a doctor, and the doctor refused to work with you, and another doctor came in and worked with you. Did you receive inferior medical care?
Possibly. I don't know, to be honest with you. So we didn't do any research on that doctor. We didn't have the opportunity to.
Did you have any complaints about the medical care that you received from that doctor?
There were some things in that meeting that were less than what we were looking for and what we expected from a pediatrician, yes.
Did you, is your daughter healthy now?
Yes, she was healthy at the time, luckily, yeah.
Is it your position that a Orthodox Jewish doctor should be required to work with an Orthodox Jewish doctor whose grandparent was killed in the Holocaust, be required to work with a Nazi patient?
Well, here's what I believe. I believe that the Religious Freedom Act, religious freedoms are a core American value. I think it's very important. I think it's important that you know that I was raised on Christian values, came from a Christian home. Me and my wife are raising our children on those same values, which is respect everyone, love thy neighbor, treat everyone equally, which is
Would you answer my
exactly
question?
right.
Should that doctor be required to take that patient?
I think that there's some people here that could answer that a little bit better than I could, but I think that everyone should be treated equally. And
Mr.
that's
Buck, if you'll yield, I'm happy to answer that question.
I
don't
will
believe
not
Nazis
yield.
are
I
a
will not yield. I
protected
reclaim
class.
my time.
Oh, okay.
I will not yield. Professor Coleman, I have a question for you.
Gentleman doesn't want an answer. He doesn't have to yield.
Well, that's a nice cheap shot from the chairman. I appreciate that. I didn't know the chairman
Not a
was
cheap
taking-
shot. It's a real shot.
Professor Coleman, under this legislation, would BYU be required to open its married student housing to a gay couple, a gay married couple?
I believe so.
And is that would you define for me what public accommodation means?
Public accommodations are hotels, restaurants, things like that.
A business that opens itself up to the public,
Correct.
including a university.
A university is an educational institution and typically is governed under a different set of rules, but Sometimes it's a place of public accommodation.
Okay, but this law does apply to public accommodations.
Yes.
And Notre Dame, the same way, would be required to open its student housing. And I'm not suggesting that BYU or Notre Dame would have a religious objection, a theological objection to that, but if they did, they would still be required to do it.
I believe so.
Okay. And is that your position also, Professor Yoshino?
I actually don't think that that's correct with regard to educational institutions. So if there's a religiously run educational institution, that religiously run educational institution would be protected in the same way that a church would be protected.
And you're saying that this law does not apply to educational institutions receiving federal financing, federal funds?
I don't believe that this alters Title VI. So, yes.
Okay, good. I appreciate that. And I yield back, Mr. Chairman.
The gentleman from Rhode Island, the author of the bill, Mr. Cicilline, is recognized.
Thank you, Mr. Chairman. Thank you to our witnesses for being here and for your really inspiring and very powerful testimony. Thank you, Chairman Nadler, for calling this hearing and for your outspoken and unwavering support of the Equality Act from the very first moment we began to discuss it nearly 5 years ago. This bill is bipartisan and now has 240 co-sponsors, including 3 Republicans. As we consider H.R. 5 here in the House, I can't help but think of the upcoming 50th anniversary of the Stonewall riot just a few weeks from now. Just 50 years ago, the patrons of Stonewall Inn in New York, one of the few places of refuge for the marginalized and criminalized LGBT community, were targeted, beaten, harassed, and arrested simply for being willing to live their true lives. That riot 50 years ago in what is now Mr. Nadler's district sparked the modern LGBT rights movement that has ushered in extraordinary achievements in our fight for equality. As a young man, I never could have dreamed that I would be the first openly gay mayor of a capital city in America, or that I would be able to serve in the U.S. House of Representatives openly and not afraid to be my authentic self. This path was made possible by activists like Harvey Milk, Bayard Rustin, Barbara Gittings, and Audre Lorde, to name just a few. And in the political world, the trail was blazed by many, including our former colleagues and my friends Barney Frank, Tammy Baldwin, Jim Colby, who is here today, and many others. And today I'm proud that we have the greatest number of individuals from the LGBTQ community in the House of Representatives in U.S. history, with 8 openly lesbian, gay, and bisexual members. I want to acknowledge and thank my LGBT Equality Caucus co-chairs who have supported my efforts on this bill: Mark Pocan, Mark Takano, Sean Patrick Maloney, Angie Craig, Chris Pappas, Sharice Davids, and Katie Hill, all trailblazers in their own right. It's important to me that young people now have the example of a diverse group of LGBT lawmakers, not just on the federal level, but across government at the state and local level. We introduced the Equality Act because we don't think it's right that members of our community are still told that they can't go to school, live where they want to live, work in their chosen field, access health care or housing. It's simply not right, and it undermines core founding values of this great country of fairness and equality. And I want to be clear that when someone votes against this bill or questions why LGBT people should have the same rights as everyone else, they're telling me that my rights and the rights of my community don't matter as much as their own comfort. Now is the time for legal discrimination against an entire community of Americans to end. Speaker Pelosi has been an extraordinary and great champion for our community and a bulwark of support for this bill, as are our Majority Leader Steny Hoyer and Whip Jim Clyburn, and our esteemed colleague and civil rights icon John Lewis. On the Senate side, we've worked in tandem with the Senate lead, Senator Merkley, Tammy Baldwin, and Cory Booker, and I couldn't be prouder to have partnered with them in this effort. As you all know, no major piece of legislation is possible without the support and advocacy of a cavalcade of experts, advocates, and allies. And I want to take a moment to thank the groups who have been so instrumental in getting this legislation drafted and introduced with such a strong showing of support. The Human Rights Campaign, and I know Chad Griffin is with us today, the president, the ACLU, the National Women's Law Center, the Center for American Progress, the National Center for Transgender Equality, the Leadership Conference on Civil and Human Rights, the National Black Justice Coalition, the National Center for Lesbian Rights, the National LGBTQ Task Force, Lambda Legal, Family Equality Council, the National Partnership for Women and Families, the Transgender Law Center, Freedom for All Americans, SAGE, PFLAG, the NAACP, the Urban League, and many, many others. I'd also like to mention that we have widespread support in the business community from companies of all sizes all across the country. Additionally, we have the support of labor groups, trade associations, such as the National Association of Manufacturing and even the U.S. Chamber of Commerce. I'd like to ask for unanimous consent to enter this list of 330 organizations and 180 companies who have endorsed the Equality Act into the record as well. We have such widespread support because businesses know that their employees thrive when they are free from harassment, when they're able to visit doctors, take their children to school, and live freely. I should note that this bill does not only provide protections for the LGBT community, we also add protections in areas of civil rights law that weren't previously in place. We expand the list of public accommodation protections in the civil rights area so that there will be recourse for people who are harassed for shopping for the color of their skin or flying because of their perceived religion. This bill will target one of the root causes of poverty, marginalization, and alienation of many in the LGBT community in this country. For example, LGBT people are more likely to live in poverty, and LGBT people of color experience some of the highest rates of poverty of any group in the United States. This can be directly attributed to the discrimination in employment, housing, and other areas that make it more difficult for people to maintain a job and earn a living wage. The Equality Act seeks to level the legal playing field so that all Americans have a chance to thrive. It's vital for Congress to be clear that sexual orientation and gender identity are protected under the law, and individuals cannot be discriminated against on this basis. But of course, any bill that expands civil rights must never retreat from our commitment to the progress that we've made, and it's vital and very important that we first do no harm. So, Mr. Chairman, under our proposal, the very same protections that exist for other minorities in the Civil Rights Act of 1964 will protect the rights of lesbian, gay, bisexual, and transgender people all across America. We're asking for no more and no less. And as my great friend and colleague, Congressman John Lewis, told me when we began this work on the bill, the time is now. I thank you, and I yield back.
Gentleman's time has expired. The gentlelady from Arizona, Ms. Lesko, is recognized.
Thank you, Mr. Chairman. I believe that all people should be treated equally, but I'm concerned that H.R. 5, with the weight of federal law, forces schools, prisons, shelters, etc., to prioritize the rights of biological males over that of biological women. H.R. 5, in the vast number of settings covered, will require that men be allowed to enter space formerly reserved for women, whereas federal anti-discrimination laws are supposed to protect women from the unjust dominance of men in virtue of their generally bigger size and strength. H.R. 5 will require that dominance of males over females in sports and incentivize it in other areas such as dormitories, locker rooms, bathrooms, and even the Girl Scouts, which is a federally chartered and federally funded organization. 9 women have sued the Poverello House, one of the largest service providers for homeless people in Fresno, California, for allowing a male resident to sexually harass them during their stay at the nonprofit's women's shelter, leering at them in the shower, showing them pictures of himself masturbating, and making sexual advances. He was permitted to do these things on the basis that he identifies as a woman. In England, Karen White, who is male, was transferred to a female prison on the basis of his self-declared gender identity. He later admitted to sexually assaulting women in a female prison and raping another 2 women outside jail. Alexis Lightcap, a high school student in the United States, is also challenging the violation of privacy caused by her own school's policy of allowing boys in the girls' bathroom. A liberal writer and gay advocate, Andrew Sullivan, writes, in opposing H.R. 5, the Equality Act also proposes to expand the concept of public accommodations to include exhibitions, recreation, exercise, amusement, gatherings, or displays. It bars any religious exceptions invoked under the Religious Freedom Restoration Act of 1993, and it bans single-sex facilities like changing, dressing, or locker rooms. It could put all single-sex institutions, events, or groups in legal jeopardy. The bill, in other words, undermines the fundamental legal groundwork for recognizing and combating sex-based oppression and sex discrimination against women and girls. Ms. Beck, do you think H.R. 5 will eliminate separate spaces and opportunities for biological women?
Thank you, Ms. Lesko. I definitely do. I believe that the language of gender identity lends itself readily to abusive gaslighting that disguises and distorts women's ability to name what is happening. Nothing is to be gained by pretending that all social issues and oppressions are gender neutral. We must be able to name sex. And for women, being female has never been a private matter. Institutions such as marriage, prostitution, enforced sterilization, and rape mark women's bodies as public domain across the world. Well, we won't have the ability to name these things if men can be women, if male people can call themselves women. So yes, we risk losing all of our sex-segregated spaces if H.R. 5 passes.
Thank you. And Ms. Coleman, do you think that H.R. 5 will eliminate separate opportunities in sports for biological women that now will be, like biological men, will be allowed to compete in women's sports?
It won't eliminate the ability to participate, but it will eliminate or reduce competitive opportunities significantly.
Thank you. I yield back my time.
I thank the gentlelady, the gentleman from California, Mr. Liu.
Thank you, Mr. Chair, and let me thank Representative David Cicilline for bringing this important legislation. So some of the arguments I hear from my colleagues across the aisle strike me as very similar arguments when their first LGBT movement started, the notion that somehow people were transgender or pretending to gain an advantage. That is what they said about gay people, that they're just pretending that they could be straight if they wanted to. It spawned this whole industry of conversion therapy that did significant harm to patients across America. It's one reason I was proud that when I was in the California State Legislature, I authored the first ban on conversion therapy in the nation. It's now been copied in multiple jurisdictions. And what we're hearing today is a very similar argument against those who are transgender. And I don't question the motivations of my colleagues. I've learned not to do that, and I don't believe they are bigoted for believing this idea. I'm simply making the point that the idea itself is bigoted, and I urge them to let it go. I served in the United States military on active duty. The U.S. military is the best in the world because we rely on data, on facts, on science. We don't live in a fantasy world because if we did, U.S. troops will die. We live in reality, and reality is women serve in combat. Women serve on nuclear submarines. Women are fighter pilots. We're simply making progress, and every time we make progress, we hear the same exact arguments repeated over and over again. So one reason that we now have Title IX and it's been successful is because Congress chose to pass it, despite very similar arguments, again, that it was, again, going to hurt women. So Professor Coleman, let me ask you, are you hearing very similar arguments today as you did during Title IX's passage in terms of how it would hurt women for equality?
I think I disagree with you. I think that it was pretty clear before Title IX was passed in 1972 that girls and women didn't have opportunities in the educational space, including in the sports area, but more broadly in the educational space, and that Title IX was going to help girls and women by providing those opportunities. There may have been some conservative positions that suggested that women belonged outside of educational spaces and outside of sport, but I think that...
I'm sorry, I was not narrow enough in my question. Okay. It was their conservative argument that women would be, in fact, you still hear it, would be assaulted.
Would be assaulted?
Right, sexually assaulted because of having their athletic facilities not be discriminatory.
Women would be assaulted.
Maybe we don't read the same conservative blogs that I
probably don't. I try to stay off of social media.
So let me ask this another way. Title IX has been a success, is that correct?
Yes.
Okay, we will leave it at that. So one of the things we know about discrimination against LGBTQ is that there's been a rise in homelessness among many constituencies, but particularly among the LGBTQ sector. So, Ms. Chandy, can you explain why that is and how we can try to make that better?
I'd like to use this question to talk about the rates of harassment and violence, because I think it relates to that. Transgender students face harassment and violence at far higher rates than their cisgender peers. And confirming earlier studies, recent data from the CDC shows that 27% of U.S. transgender high school students feel unsafe at school or traveling to or from campus, that 35% are bullied at school, and 35% attempt suicide. Similarly, a survey conducted by the National Center for Transgender Equality found that the majority of respondents who were out or perceived as transgender in school in K through 12 experienced some form of mistreatment, including being verbally harassed, 54%, physically attacked, 24%, and sexually assaulted, 13%, because they were transgender. And startlingly, 17% of respondents experienced such severe mistreatment that they left school as a result. Respondents who did not complete high school were more than twice as likely to have attempted suicide as the overall sample. And finally, in a survey conducted by the American Association of Universities, nearly 1 in 4 transgender students experienced sexual violence in college, a higher rate of victimization than that experienced by cisgender college women. I wanted to share these statistics because Congress designed Title IX to address sex discrimination across the board, including women and including transgender individuals. And we are continuing to fight against this narrative that puts women's rights on one side and LGBTQ rights on another, or the rights of transgender people on another, because transgender women are women. And so all of us need this protection together. And that's why would the National Women's Law Center and the host of women's rights organizations be here in support of the Equality Act if it was going to harm women? We are the experts on this. This is what we do day in and day out across sectors, workplace, healthcare, workplace justice, education, all of these areas. This is what we do, is we fight for women's rights. And so please look to us as the experts on whether or not this bill is good for women and LGBTQ people.
Thank you.
Time of the gentleman has expired. Before I recognize the next person, I ask unanimous consent to insert into the record a letter from more than 40 trade and professional associations in support of the Equality Act. Without objection, it will be entered. Now I recognize the gentleman from California, Mr. McClintock.
Thank you, Mr. Chairman. Last week, I had the privilege of visiting with an endocrinologist from my district, Dr. Michael Laidlaw. He's witnessed the medical dangers of this obsession with new transgender ideology, and specifically how dangerously it's being pushed on children as young as 8 years old, which will only be made worse by this legislation when parents are threatened with lawsuits or the loss of their children for questioning their child's gender dysphoria or objecting to life-altering therapies or surgeries. And I'd like to submit 3 items for the record. First, a letter he wrote outlining what he's seen and his concerns for how H.R. 5 will elevate children's feelings about their gender over biological and medical reality. Second, a piece he wrote in the Journal of Clinical Endocrinology and Metabolism, calling for more skepticism among physicians who treat young people claiming gender dysphoria in light of the highly detrimental health consequences of gender-affirmative therapy, such as increased ovarian cancer, lower bone density, and thrombosis and pulmonary embolisms. And third, an excerpt from an NIH report indicating that NIH has lowered the minimum age for inclusion in their studies about gender transition hormones from 13 to 8 years old, which I find truly disturbing. I'd like unanimous consent to enter those into the record.
Without objection.
I'm hopeful that these documents, along with all of the other questions raised by my colleagues today, will give pause to those who are championing the embrace of this radical trans ideology over biological reality. Ms. Beck, am I safe to assume that we should all agree that gender-based stereotypes about how men and women should speak or act or dress or appear should not be the basis of our interactions as a society.
I would only agree if you use the word gender as a synonym for sex. I don't agree with...
How somebody chooses to act, to dress, to talk, really should not be an object of notice by their government, should it?
I mean, these are all personal traits that are subject to change any day, any hour. I mean, my hair grows, you know?
Exactly, and we shouldn't assume that these stereotypes, we shouldn't use these stereotypes to craft statutory or legal definitions on discrimination.
I agree. Like I said earlier, there's no way to tell if someone's lying about being transgender. So if a man who wears a dress is considered as a woman by federal law, he could be lying, and there's no way for us to tell.
Well, that's the question I want to get at. H.R. 5 gives us a definition of gender identity that's based on stereotypes. Let me read from the text of the bill. It says, the term gender identity means the gender-related identity, appearance, mannerisms, or other gender-related characteristics of an individual. The drafters of this bill could have saved themselves some legalese and just said gender identity means gender stereotypes. What does that say about this movement that the lawyers drafting this bill are unable to define gender identity without relying on stereotypes?
It says not much because they haven't written much, unfortunately. I find it really disheartening that we're debating a federal law that is just incomplete and baseless. We've given a lot of testimony to show how this would affect women negatively, and that's just we were told to let it go. This would eliminate women and girls as a coherent legal category worthy of civil rights protection.
Well, let me ask you this. I would assume that you would support the numerous efforts by the government over the last several decades to promote women-owned businesses, for example, by giving women-owned businesses preference when competing for government contracts.
Sure, yeah. I think that's all great on the basis of sex.
Well, what should we tell a woman-owned business that loses out to a government contract because a man decided to identify as a woman in order to win that contract?
That should never happen.
Ms. Tandy, doesn't that happen under this bill?
Use your mic.
Yeah, what would you say?
Transgender women are women. And so I find this sort of language about calling transgender women by some other name to be not in line with.
Well, whatever language you would choose, the question remains, what would you tell a woman-owned business that lost a contract because a man decided to identify as a woman in order to win that contract?
Okay. If it was a transgender woman, I would say, you lost out. Another woman won. It was probably a better application.
Well, so let me ask you this.
Let me finish. If it was a man who is trying to be fraudulent, I would do an investigation on fraud.
Yeah, but how are you going to know if he's trying to be fraudulent? No, because the time is mine. I'm out.
Okay.
Mr. Chair, may I ask the witness be permitted to finish your answer to that last question?
Well, if I can have a follow-up question.
No, your time has expired, but the witness gets to answer the question.
I'll let, excuse me a sec. Let the witness answer the question, and I'll grant the gentleman an additional question.
Thank you. I mean, this question of people being able to lie about their gender identity, I find so interesting because I think someone raised today, people can lie about being gay. People can lie about being a lesbian, and yet we need rights because we're gay or lesbian. The same rights apply. These are not things that people lie about to gain rights. These are things that are the basis of really painful discrimination, as we've heard from so many of us. And so to go ahead and mispronoun and misname people based on their true identity and these questions are coming at me in a way that don't make sense. If it's a man who's pretending to be a woman, then that's fraud. If it's a transgender person, then it's a woman.
But under your criteria, the only way to decide if the person is lying is to read their mind, which is beyond our abilities. And I want to ask you, what if every government contractor in America decided to identify as a woman? What mechanism is there for the government to verify that all of these men who do government contracting are identifying with women for gender for genuine gender transition as compared to trying to game the system. You can't tell unless you can read their minds, and I doubt you can.
The time of the gentleman has expired. The witness may answer the question.
I mean, I would just say that's not how civil rights laws work. There are individuals who have protections based on race. You may or may not be able to tell what their race is. I mean, there are protections based on if you're LGBTQ that have been in effect across our country in half of the states. Sometimes you can tell. Sometimes it's because of a perception. That person might not even be LGBTQ, but you think they are and you discriminate, and that would be discrimination. And so this idea of not being able to tell is not really an issue in civil rights law.
The time of the gentleman has expired. The gentleman from Maryland, Mr. Raskin.
Mr. Chairman, thank you. Sometimes when you're in the middle of the trees, you lose sight of the forest. So I want to make sure we remark upon what a great and historic day this is, that we are taking up the Equality Act, and I believe we've got a majority in the House of Representatives ready to pass it, and I think there's a majority in this committee ready to bring it to the floor. I want to salute my colleague, David Cicilline, for his really passionate advocacy and stewardship of this legislation. Your name will go down in history, Mr. Cicilline, with other great members of the Judiciary Committee in our past, like Thaddeus Stevens and Peter Rodino, and other great members of Congress like Everett Dirksen and Hubert Humphrey and John Lindsay, Republicans and Democrats both, who stood up for equal rights against always a barrage of increasingly absurd and desperate arguments mounted by the opposition. The second thing I want to say is I would be glad at the end of my remarks to grant my colleague from California any time if he can find a case of a man impersonating a woman who received any kind of small business advantage or credit. And if there's one, I would love to know about it, either a man who impersonated and was prosecuted for it, or a transgender person who was proven to have engaged in a fraud on the government. I'd be happy to yield for that purpose. Now, what I want to talk about...
Is the gentleman serious about yielding?
If you can find an actual case when I get to the end, I've got something important. Okay, I'm reclaiming my time now. You're going to have to stew on that for a second. Okay, the H.R. 5 is going to help improve outcomes for more than 437,000 children and young people in the child welfare system. Over 120,000 children waiting to be adopted. Now, we know that the opponents of marriage equality were greatly disappointed by the Supreme Court's historic pronouncement in the Obergefell decision, which wiped away their arguments, of course, that if you allow gay people to get married, it would destroy and erode the institution of marriage. Tell that to two of my nieces and my younger sister, all of whom got married in straight marriages since Obergefell took place. Obviously, the expansion of marriage to include all of our citizens didn't undermine marriage at all. But now they've trained their guns on a different site. They're saying, well, these married couples should not be allowed to adopt children. Currently, 10 states, including Virginia, across the river, allow discrimination against same-sex couples who seek to foster and adopt children. And 2 more legislatures today have bills pending before them to accomplish that same objective. This is a profoundly troubling offense to the equality norm and to our nation's commitment to children and to our young people. These states are placing the ideological commitments of some grown-ups over the practical welfare and happiness of tens and hundreds of thousands of children and young people. Think about that for a second. They're saying that they would prefer to have kids either not get adopted or placed in a foster home at all than to be with a lawfully married couple that they disapprove of. That's a remarkable thing. And we're going to take care of that with the Equality Act. This is a magical moment for our country. We are expanding equality. This is the whole history and trajectory of our Constitution, of our laws. We started as a slave republic of white male property owners over the age of 21, and through social struggle and social connection and the moral discovery of the people that all human beings really are equal. certainly in the eyes of the Constitution, if not in the eyes of God, according to some, if not in the eyes of other citizens, according to some, in the eyes of the Constitution, all of us have to be equal. And so we've expanded ourselves to do that. So we've seen in some of these states, the adoption levels go down because you're removing lots and lots of very qualified families that want to adopt. In fact, one study showed that 70% of same-sex couples want to form families, and 40% want to do it through fostering adoption. Now, why, for the life of us, would we remove them from the roster of parents who are ready to adopt? Why would we do that? Unless you have bigoted and prejudiced ideas about the ability of gay people to parent and to form families. By the way, those are bigotries and biases that are contradicted every day by LGBT parents across the country. So let's see, I've got an embarrassment of riches here, but let me ask you, Ms. Chanty, about this. Is this not a problem today that in many states, or some states, it's a minority of states, but in some states, that the LGBT community is being locked out of foster care and adoption?
The gentleman's time has expired. The witness may answer the question.
Yes, I mean, of course, turning away qualified LGBTQ foster and adoptive parents, limits the pool for children. And I also want to make the point that this really is harmful for the children because 1 in 5 foster youth identify as LGBTQ. And this takes away the chance that that might be put with an affirming family. And there's over 400,000 foster kids in America, and we need to have all of the families who are willing to be in the pool to take care of them. And so I would just heartily agree with you that we cannot exclude LGBTQ potential parents from this. And as adoptive parent myself, obviously I take this very personally to think that I would go to an agency and they would turn me away.
The gentleman's time has expired. The gentlelady from Florida, Ms. Demings.
Thank you so much, Mr. Chairman, and thank you to all of our witnesses for your testimony today. Just saying that you support equal rights or women's rights, I think that's more interesting what is going on over there. Just saying that just saying that you support equal rights or women's rights or civil rights isn't enough. Because the American people are always watching what you do, not just listening to what you say, but watching what you do. As great as we are as a nation, I'm just amazed that we just simply cannot yet seem to get past racial discrimination, sexual discrimination, or discrimination of any kind. For some reason, America just cannot seem to get past tearing other people down who are different in some way for us. You all know the history of our country. Our past is so ugly in this area. I would think that we would all do everything within our power to make it right. But instead, we sit here today, at least my colleagues on the other side of the aisle, and look for a technicality to continue to justify discrimination in what I do believe is the greatest country in the world. We've heard about discrimination in housing. We've heard about discrimination in employment. We've heard about discrimination on so many different areas that are necessary to living a quality life in this country. But yet, we are overruling all of that based on this belief that there may somehow be discrimination in the area of sports. Now, I played sports, and I do not believe that it takes precedence over my ability to love whomever I want to live wherever I want to live, to work wherever my qualities as an individual take me, or to be my authentic self. All of you have added very important testimony to this conversation, but Reverend Wiley, I want to go back to you. And I know you so eloquently in your opening statement talked about why this matters to you, but just for all of our sake, as we wrestle with discrimination still yet today, you grew up in the Jim Crow era in the South, and I want you to tell me, why does that motivate you so much as it pertains to this issue today? And what would you say to those who argue that it's inappropriate to equate racial discrimination with discrimination on the basis of sexual orientation or gender identity?
First of all, I would say that injustice anywhere, as M.L. King said, is a threat to justice everywhere. And again, I have just developed a sensitivity to the fact that having gone through what I went through as in the segregated South has sensitized me to the injustice of discrimination toward anybody. And one could say that no two discriminations are the same. I mean, racial is not the same exact kind of discrimination as LGBTQ discrimination or gender discrimination, but it's still discrimination. So that if any of us have, and so in moving from Winston to Washington, even though Washington itself has a sordid history of discrimination as well in the past, and we're seeing some things even in the present that remind us of that. But again, I think that if we believe in a society where all people are created equal and everyone is entitled to life, liberty, and the pursuit of happiness, either we're telling a lie when we say that, or we really mean it. And I think that if we really mean it, then we are open to whatever needs to be done to make it a reality.
Thank you, and Mr. Chairman, I yield back.
The gentlelady from Pennsylvania, Ms. Hanlon.
Thank you. You know, this is a personal issue for me. As we said yesterday when we were talking with some of these folks, it's been personal since my baby sister came out to me 40 years ago. And for many people in this country, that's when the fight hits home. It gets personal when someone who you love says, "This is who I am," and you know and value that person, and you'll do whatever you can to make sure that your loved one can live their life to the fullest, free from hate and discrimination. I do want to recognize and remember Shantae Tucker, a transgender woman of color from Philadelphia who lived at the intersection of racial and sex and gender identity discrimination. Last fall, she was murdered. And that is something we hear time and time again, that when all of these discriminations coalesce, that's where there's even more serious danger. I'm sad to say that my home Commonwealth, Pennsylvania, is one of the 30 states that has not adopted anti-discrimination provisions in this arena. We don't have legal protections on the book for LGBTQ people. And the idea that my sister or anyone else could drive across state lines and either gain or lose protections is both heartbreaking and, I think, profoundly un-American. So that's why we need this bill. I was really interested in Ms. Silas's testimony about IBM and the other major corporations that are really taking the lead in this arena and making the business case for why this law is important. I did want to ask a question to Ms. Shandy. As we talk about the patchwork of laws across this country, in Pennsylvania last year, the state's Human Rights Commission announced that it would accept complaints dealing with sexual orientation or gender identity discrimination, even though no federal or Pennsylvania state law explicitly addresses those issues. So why is it important that we have a federal law to address this issue?
Sure. As you've noted, there are states and localities for many, many years that have had protections based on sexual orientation and gender identity, and while, including DC, and while the individuals who live in that jurisdiction are able then to bring explicit complaints, as you said, if you go across the state line, then you don't. And so I think we want to have a country where all of us have these protections as LGBTQ individuals. As we also mentioned, some of the court cases are evolving in this way to say that the federal protections of sex discrimination also provide protections if you are discriminated against based on sexual orientation or gender identity. Again, that's dependent on circuits, meaning sort of regions. And so these rights cannot be dependent on states, localities, or federal regions. They need to be for all of us.
Is it fair to say that if the character of the federal judiciary were to change, for example, if a whole host of more conservative judges were appointed, that could imperil some of these advancements in the federal courts?
Yes, that is correct, because until we have a statute, a federal statute that gives clear and explicit protections, some of these decisions are dependent on the discretion of federal district judges and circuit judges. So yes, the makeup of the judiciary can impact on these interpretations until we have a federal statute that protects all of us.
Okay. I've spent the better part of the last 30 years working on issues involving public education, and I'm really proud now to serve on the Transgender Equality Task Force with Congressman Kennedy. So earlier this year, we sat down and had a couple sessions with parents and children in schools talking about their experiences as transgender or gender nonconforming youth and their struggles and the bullying and the bureaucratic roadblocks they'd face. Can I ask you about how the Equality Act would affect those students?
Sure, and with permission, I'd love to bring in Carter Brown, if you're willing, given that we have someone who might be able to speak to that more personally. I will just say that this law would provide additional protections, but really I would defer if you don't mind.
Sure, thank you. In my experience when working directly with the transgender community, we've heard lots of stories here today about the damage that the option to transition does to children. I've heard I can combat those stories double with positive stories of children, personal testimonies of children and their parents that stated the opportunity for their children to be able to transition and live authentically with support has given them so much fulfillment in their life and enriched their quality of life. I can say for myself personally, if I had the opportunity to transition at a much younger age, I would feel that I could have achieved much more having not been ostracized in school settings or a negative effect on my social life overall and my ability to access opportunities in education and employment and things that every other American is afforded. I do believe that a person's gender identity is a very personal thing, and it's not something that can be defined by anyone else, and it's definitely not something that anyone wants to perpetrate for the purpose of hurting someone else.
The gentlelady's time has expired.
Thank you.
The gentleman from Colorado, Mr. Neguse.
Thank you, Mr. Chairman, and thank you to the witnesses gathered here today for your testimony. Fairness and equality, in my view, are core American values. Our nation's civil rights laws protect people on the basis of race, national origin, in most cases, sex, disability, and religion, and yet, when it comes to sexual orientation and gender identity, as we've heard today, more than half of our states still lack explicit laws to protect people from being fired, refused housing, or denied credit simply because of who they are. We cannot grow complacent in the quest for equal rights for all, and that's why I'm very glad to be a co-sponsor of the Equality Act and proud that the chairman and this committee are taking up this issue. Prior to serving in Congress, I had the distinct honor of running our state's regulatory department in the great state of Colorado, which included the Civil Rights Commission. The Masterpiece Bakery case that the professor mentioned earlier happened to be a case that originated in that agency. I'm also proud that my home state of Colorado took an important step towards equality over a decade ago by making it illegal to discriminate on the basis of sexual orientation and gender identity in employment, housing, public accommodations, education, and credit. And it is long past time that we emulate those important protections at the federal level. It is time that we get this done. And so again, I'm very grateful to Representative Cicilline and to the many co-sponsors of the Equality Act. Mr. Brown, I want to give you a chance to talk a little bit, and if you'll indulge me, I first want to say thank you for sharing your testimony and for sharing your story, which I think is just incredibly important. Your honesty and the strength that you've shown by being here this morning, I guess it's afternoon now as the hearing goes on, and ultimately your approach I just think is incredibly admirable, and so I thank you for that.
Thank you, sir.
And I'm of course sorry, as I know the committee, my colleagues in the committee are, to hear about the discrimination that you faced and the toll that it took on your family. Just a couple of weeks ago when I was back home in Colorado, I had a chance to meet with a group of LGBTQ individuals and allies at Out Boulder County. And Out Boulder is the perfect example of a grassroots, locally driven organization that's made strides in our community because of its ground-up approach to building support for the community. But the first thing they brought up when I met with them, with respect to the concerns that they had in the community and sort of nation at large, the issue they talked about the most was the need to have proactive support for the transgender community. They have obviously felt, been under attack quite constantly by the Trump administration, but we also ought to be fighting for the transgender community even when they aren't under attack in the news. And so, Mr. Brown, the question is, outside of the Equality Act, which I fully support and look forward to voting for, what other steps would you recommend this committee or the Congress in general take to better support the transgender community?
Well, my understanding of the law is that it's not to persuade personal beliefs, but to provide personal protections for all of its citizens, period. So I feel that to have more support for the transgender community to be made into law simply gives all Americans equal citizenship. For me personally, I feel that if the Equality Act is passed, that allows me, it not only protects my identity as a black person, and not only protects my identity, or my faith in God, but it also protects my gender identity, which is innately all of me and my characteristics. None of those characteristics are less than or more than. They all make me. And as a hardworking American citizen and as a taxpayer, I deserve the same rights as my neighbors. And that's simply put. So I feel that not only familial support when we're talking about suicide and suicidation in the transgender community, that's generally due to lack of support, due to lack of access to health care, due to lack of being integrated into society as anyone else, creates depression and mental health problems for many people. And I would equate that to, as the Reverend Doctor stated, with the discrimination against black people, when we're talking about separating black people from schools or separating them in sports because it was believed that they could jump higher or were stronger, or separating them, or even gay people, separating them in school lockers because we were afraid that the gay boys would attack the straight boys, etc. This is the same thing of just hate mongering and inflaming fear for isolated incidences where a crime was committed by someone who happened to be transgender, and inflicting that prejudice onto a whole community of people does nothing but continue to divide us as Americans, as opposed to actually bring us all together as a United States, as we say we are.
Thank you, Mr. Brown, and I see my time has expired. If the chairman would indulge me in 4 seconds to just simply say thank you to Ms. Silas in particular, and to IBM's voice. I happen to represent Boulder, Colorado, where IBM is headquartered, and so I'm grateful for your support of the Equality Act and leading in the business community on this front.
Thank the gentleman, the gentleman from Arizona, Mr. Stanton.
Thank you very much, Chairman Nadler, and I want to thank the outstanding witnesses here today for your testimony. I also want to thank my friend, Congressman Cicilline, for your long-term leadership in drafting this Equality Act and shepherding through this process. And with the help of the new members of Congress this year, we're going to get passed through Congress. So thank you for your leadership, Congressman. Cities across the country recognize the importance of ensuring all people have the ability to live and work without fear of discrimination because of who they are. We certainly understood that in Phoenix, and during my time as mayor, we sent the message that everyone is welcome, regardless of sexual orientation or gender identity. To me, it's simple. Our communities are stronger when they are inclusive and welcoming, and what's more, our economy is stronger. So today I want to underscore the Equality Act's potential economic impact. In 3 specific cases in Phoenix, we saw that taking action to prevent discrimination had a positive economic impact. In 2013, we passed a citywide non-discrimination ordinance to prohibit discrimination on the basis of gender, sexual orientation, and disability in employment, housing, and public accommodations. As a result, Phoenix earned national recognition as a city promoting equality. Socially conscious companies look to our region as a place that aligns their vision for inclusivity, and they are expanding to create jobs and do business in our city. In 2014, we stood up against a proposed state law that would have allowed businesses to discriminate against customers on the basis of religious belief, the so-called bathroom bill. We joined businesses across Arizona and the country to demand that the governor reject the bill, and major corporations, including Apple, AT&T, American Airlines, spoke out too. Even the National Football League considered moving the 2015 Super Bowl if the bill were to become law. A clear example that pushing discriminatory policies puts us at economic risk. Under pressure, the governor did ultimately veto that bill. In 2016, Phoenix joined other U.S. cities in offering transgender inclusive health care benefits to city employees and their families. This sent a strong message to our transgender public servants. You matter, and we value you. Providing those benefits was vital to the well-being of our city employees and continues to make the city of Phoenix a more sought-after employer. We learned in Arizona that inaction has consequences. Allowing discrimination to take place or not being proactive about outlawing discrimination pushes out talented people our cities need to thrive economically. More proof. A study from the Williams Institute found that, quote, when LGBTQ people are targets of violence, denied equal access to education, stigmatized in communities, and discouraged from pursuing jobs that maximize their skills, their contributions to the whole economy are diminished, holding back economic advancement for the national economy, end quote. The bottom line is that LGBT individuals want to live and work in places that embrace them. States and cities have been doing the heavy lifting when it comes to preventing discrimination, and it's time for this Congress to act. The Equality Act is the overarching legislation that our country needs right now. Here's my question. It's for Ms. Silas. You mentioned in your testimony that IBM is a place to create supportive and inclusive environment for all of your employees. And I want you to speak a little more, maybe expound upon that a little bit. Can you speak to the importance of having inclusive policies in terms of recruiting, retaining talent? I believe corporate America has been way ahead of the political side in terms of promoting inclusivity. Please.
Yes, thank you for that question. So, the reality that we sit in today is there are 500,000 technical jobs open right now, right? And certainly when we think about IBM and our talent needs and venturing into spaces such as blockchain and cybersecurity and quantum computing, all of which are incredibly important spaces for innovation and advancement in the technical field. We are not in a position where we aspire to handpick people based on anything other than skills. I have no interest in discriminating against people based on personal attributes. It doesn't make good business sense. Beyond that, I'm proud to work for a company where we are grounded in the belief that our actions need to absolutely result in business growth, and it's why we're focused on skills. But we also have a 100-year history of focus on societal impact and how do we use our role and our impact on society to drive fairness and equality. That is also good business.
All right, thank you very much. The Equality Act is good for the American economy, good for business. Mr. Chairman, I ask unanimous consent to insert into the records the Williams Institute study that I referenced called The Relationship Between LGBT Inclusion and Economic Development, an Analysis of Emerging Economies.
Without objection, documents will be admitted.
Thank you.
Gentleman's time has expired. The gentlelady from Pennsylvania, Ms. Dean.
Thank you, Mr. Chairman, and I thank all of you for coming and talking with us today in this important conversation about how we create a more perfect union. If you notice, some of us are leaving this room. We're going in and out to other hearings. And I happen to be going to a hearing across the hall, not very far away, and it's not very far away in terms of what we're talking about. It's the financial services hearing on fair housing. And as I stepped in there to have my opportunity to listen in and to ask some questions, Ms. Johnson, who's an expert on LGBTQ issues, said, we must name sexual orientation as a protected class. It's interesting how these two conversations are meshing. And so in the frenzy of running between and in the sausage making that you're all watching, I just want to commend the chairman for hosting this committee, because in the search of a more perfect union, we have to have these messy conversations, these uncomfortable conversations. I thank the chairman. I thank Mr. Cicilline for his extraordinary leadership in this legislation. Some things that I wanted to examine, Ms. Silas, in terms of IBM, we sometimes talk about we don't want to discriminate because it's not the right thing to do. But economically, it's the right thing to do to make your workforce as diverse as possible, because our diversity actually makes us stronger. Our diversity comes up with creative solutions. Is that IBM's experience?
It certainly is. I mean, it's not abnormal when we talk about the benefits of how our teams work and embedding diversity, that we strongly believe that diversity helps us do things like, mitigate groupthink, or identify errors more efficiently, or innovate more effectively. And that's core to how we work. And ultimately, it's how we thrive as a business. So it's absolutely normal and core to how we work.
So it's not only the right thing to do, it's the economically smart thing to do, to come up with more creative solutions. And Reverend Doctor, I really appreciate your experience and your testimony and your years of pastoring to so many. Before you even had your very personal connection, you were already pastoring on this subject, because you understood it as a subject about our common humanity, and you understood it as a core subject of love. How we love one another is actually what should guide us. So you might imagine that I am extraordinarily puzzled by the conversation that has been going on, by some of the testimony here, but also by some of my colleagues on the other side of the aisle that throw up what I think are rather phantom fear-mongering examples of fear of invasions of bathrooms, invasions of shelters, invasions of sport. I don't understand that in the balance, even if any of those anecdotally things were true, on whole, on the measure, in the balance of how we move forward in this country, are we to be held back by those phantom anecdotes, or are we to look for a more perfect union and to stop discriminating? And so I wanted to give whomever the opportunity, and I really commend Mr. Brown, Ms. Contreras, and Professor for your compelling personal testimony. And as I am one of the last to question you, is there anything you realize in this conversation we really haven't heard about in personal discrimination? Because I was a township commissioner a long time ago, not so long ago, in Abington Township, Pennsylvania in 2012, when we passed this as an ordinance, this bill as an ordinance. And people kept saying to me, come on, is there really discrimination in housing? Is there really discrimination in accommodation? Well, your testimony shows beyond measure the extraordinary, heartbreaking discrimination. What else have we missed? What else should people know so they understand the importance of this law?
We should understand that sexual orientation is not the same thing as gender identity. These two things are very different, and in fact, one invalidates the other. Gender identity language obfuscates sex. One of my colleagues in the Baltimore City LGBTQ Commission, before I was kicked off for using male pronouns to talk about a male rapist, one of my colleagues said that sex was fake, sex was a thing of the past, that science had progressed so far that we didn't even need to worry about it. And I asked him, how could we be gay if sex is fake? Gender identity obfuscates sex. So we can't legislate one thing while it invalidates the other.
I thank you, Ms. Beck, and I understand you do not understand this as a civil right. So I actually was asking for some other input. Thank you.
Great. Just a couple of things that I think might be useful, Representative. One is thinking about the assault issue that you raised and that one of your colleagues on the other side of the aisle raised with the Karen White case. It's interesting that we need to travel abroad to the UK to find that example, because we have seen no examples of that, to my knowledge, on this side of the pond. That was a case of really unfortunate assault, but of both men and of women. So the only thing that could have prevented that assault are the things that we have in our criminal law and in our tort law that abolish and punish assault and criminal behavior as such, rather than sex segregation per se. And in fact, that individual, it was interesting that no one thought to mention, is serving a life sentence in jail, right? So that we do have redress within our criminal law for egregious actions of that kind without having to resort to excluding trans individuals from sex segregated spaces. And in fact, one of the painful ironies of this entire hearing is that we hear over and over again trans individuals being cast as the perpetrators of assault and harassment, where statistically there's no evidence that trans individuals are more likely to perpetrate assault or harassment. And in fact, exactly the opposite is true. Trans individuals are much more likely to be the victims of assault and harassment, and that's exactly what the Equality Act would cure. The only other thing that I would like to mention has to do with the freedom of religion issues that have been raised. I was a bit puzzled to hear one of the representatives say that the First Amendment is one of our first freedoms and therefore should be enshrined, given that this act under the Supremacy Clause does nothing to disturb and could not disturb the Free Exercise Clause jurisprudence that the court has articulated. So that is a constitutional amendment. There's nothing that ordinary legislation can do to alter that or the protections in place under the Free Exercise Clause.
The time of the gentlelady has expired. The gentlelady from Washington, Ms. Jayapal.
Thank you, Mr. Chairman. And I just want to say thank you so much to so many of you that have given beautiful, beautiful testimony today. I have my pack of Kleenex here because I found it deeply moving. And I want to remind anybody that might be watching what we're talking about today. The Equality Act is a landmark civil rights bill to make clear that discrimination against LGBTQIA people has no place in our society. It rectifies an unacceptable situation and sets forth comprehensive protections against discrimination on the basis of sexual orientation or gender identity. As I listened to some of you today, I was struck by this push to presume that these provisions would somehow be manipulated or used by people in ways that would hurt existing sex protections. And I was struck so much, Reverend Wiley, by your beautiful testimony. And it occurred to me that we're talking about fear versus love. We're talking about fear versus freedom. And I didn't intend to say this today, but excuse me. My beautiful, now 22-year-old child told me last year that they were gender nonconforming. And over the last year, I have come to understand from a deeply personal mother's perspective. I've always been a civil rights activist. I've always fought for my constituents and my communities to have equal rights. But from a mother's perspective, I came to understand what their newfound freedom, it is the only way I can describe what has happened to my beautiful child, what their newfound freedom to wear a dress, to rid themselves of some conformist stereotype of who they are, to be able to express who they are at their real core. And since this deeply impactful moment last year, my child, who has always done well in school, but has carried what a mother can only describe as a heavy burden of conflict in their own being that I could not fully identify or help to express. Since this deeply impactful moment last year, my child's embracing of their non-conforming gender identity and all that it has allowed, all that it allows in terms of their creativity, their brilliance, their self-expression, the only thought I wake up with every day is my child is free. My child is free to be who they are. And in that freedom comes a responsibility for us as legislators to protect that freedom, to be who they are, and to legislate, as Dr. Wiley so beautifully said, to legislate our behavior towards all people in our society. So let me go to some questions. Washington State has had protections for transgender people since 2006, and we have never had issues such as those that are being raised today as fears. So, Ms. Beck, I know you've described yourself as a lesbian radical feminist. You last appeared before this committee during the hearing for the Reauthorization for Violence Against Women Act, which incorporates gender identity in its non-discrimination provision, and you criticized these protections saying that, quote, predatory men will do anything to gain access to victims. And you went on to say that acknowledging biological sex is not inhumane, it's actually inhumane to force women to share intimate spaces with male people who call themselves women. Is that correct?
Correct.
Thank you. Ms. Chandy, as legal director at the National Women's Law Center, you're an expert not only on LGBTQ rights, but also on gender and women's issues. In your expert opinion, is it problematic to have inclusive spaces that provide safe spaces for transgender people?
No, as we've talked about here today, sexual assault happens across all kinds of workplaces and schools and many, many settings, and does not require some, sex-segregated spaces for that. There's no evidence that having trans-inclusive, sex-segregated spaces would lead to more sexual assault. But I could also say on a personal note, I have so many South Asian LGBTQ organizations and would love to connect with you around that to provide support if that's useful.
And I'm a proud Carolite, by the way, so
wow.
happy to have you here.
You can talk to my parents then.
Let me just, my time is expiring, but I wanted to ask Mr. Brown if you could just share what these protections for transgender people in the Equality Act would mean for you and your family. Ms. Beck has said that she opposes protections for transgender people, and I would just like to hear from you from a very personal perspective. What would it mean to have us pass the Equality Act with these transgender protections?
The gentlelady's time has expired. The witness may answer the question.
From a personal perspective, having the Equality Act passed would provide safety for me. We hear a lot about we've heard a lot today about transgender people being a threat in the bathroom, in sports, in the workplace, so forth. My experience, I need protections. I do not feel safe in the workplace. I do not feel safe in the bathroom if someone knows that I'm transgender. I know a lot of transgender men that have been harassed and attacked in the bathroom because they were transgender. I need protections for me as a trans person. My identity is not a threat to anyone else. As it stands, it's a threat to me and my ability to provide for my family, to work hard. And in the intersections of my gender identity and my race and my class, it is not a level playing field as an American, as a person who's worked hard to complete school, to buy a home, to pay taxes, and all the things that America promised me as a freedom and as my right, an inalienable right to pursue my road to happiness, is now being threatened because I have no protections.
Thank you, Mr. Brown, and Mr. Chairman, thank you. I just want to say that this is such an important bill. I thank Mr. Cicilline and you, Mr. Chairman, for having this critical discussion on how we move forward as a country.
Thank the gentlelady. The gentlelady from Florida, Ms. McCarcel Powell.
Thank you, Mr. Chairman. And I truly applaud the courage from the members of the panel that are here with us today. Thank you for being here. The courage of a mother, my colleague, Representative Japayal, who is, with her words, truly touches each and every one of us. And David Cicilline, who has been fighting every battle to ensure that we finally protect every individual regardless of gender identity or whom they love. This is the United States of America. Equality is equality. And I have to say that every time I come to this committee and I sit through hours of hearings, whether it's passing universal background checks bill, the Violence Against Women's Act, I hear from my colleagues across the aisle things that make absolutely no sense. And I just wonder if these comments are based on fear, is their masculinity being threatened? Are they scared that all of a sudden, by passing the Equality Act, their favorite sports team is going to lose to some female sports team that now has males that are pretending to be women so that they can participate in female sports? It makes absolutely no sense. I can tell you that I'm very proud to represent a community where our motto is one human family, and that is Key West. We have elected our mayor back in November, who is openly gay mayor. We have a police chief who is openly gay. We welcome over 450,000 tourists who are members of the LGBTQ community. Our rates of violence are lower than any other community in Florida. I am proud to represent Key West. We should all learn from that community what it means to be a member of one human family. And since I hear a lot of words from my Republican colleagues about fear, bad actors, I'm going to talk to them on terms that maybe will grab their attention, and that's the economy and money in their pockets and what it means to lose businesses or employment opportunities if we discriminate against our brothers and sisters from the LGBTQ community. I would like to, Mr. Chairman, ask for unanimous consent to include on the record the list of companies that are endorsing the Equality
Without
Act.
objection.
ADP, American Airlines, Bayer US LLP, Booz Allen Hamilton, Choice Hotels International, Cisco Systems, Deloitte LLP, Diageo North America, Ernst & Young, Google, Hyatt, IKEA, Intel, Lyft, Marriott. The list goes on and on and on. So it's not just a social justice issue. This is an economic issue. So maybe that will bring attention to my colleagues across the aisle. So to that effect, I would like to ask some questions for Tia Silas. Ms. Silas, according to the Human Rights Campaign 2019 Corporate Equality Index, 93% of Fortune 500 companies have non-discrimination policies that include sexual orientation, and 85% Fortune 500 companies have non-discrimination policies that include gender identity. Why are businesses proactively adopting explicit LGBTQ non-discrimination policies?
Thank you for the question. So I stated a little bit earlier that it really is around access to skills that allow our business to thrive, and the fact that we have, at least 500,000 in my space technical jobs open, and so we need to care about skills. I'll also touch on something else I haven't been able to speak on, which is why a company would care about protections beyond the four parameters of our wall. So thinking about things like housing and credit. And for IBM, our particular story is one where we understand that if we're only concerned about protections within our four walls, then that puts us at a competitive disadvantage in recruiting people. I often reference we did, my predecessor, a guy by the name of Ted Childs, led during an era where we were really progressive around the recruitment of minorities, Hispanic, Blacks into our Westchester, New York area. It was important for our headquarters. We found that while we were fairly aggressive working with HBCUs and incredibly successful in recruiting people, that when we went to relocate them in the Westchester community, that they were unable to get access to things like housing or credit to get a car. And we had to go out into the community. We were one of the founders of an organization called WRO, so that we could advocate for holistic and 360-degree fairness and equality for our employees. So we've learned through our 100 years, right, that it is important for us to care about what we can control within our four walls, but we rely really on you, right, to ensure that there are protections across state lines and beyond employment.
Thank you, Ms. Ellis. Thank you, Mr. Chairman.
The time of the gentlelady has expired. There are 8.5 minutes left on the vote. We're going to try to finish the hearing and ask them to hold the vote open. So I'm going to be more strict on the 5-minute rule. Gentlelady from Texas, Ms. Jackson.
Thank you very much, Mr. Chairman, and thank you for this hearing. David Cicilline, the journey is continuing, but thank you for the passion, and we commit to you and all of you that we will not give up the fight. Let me indicate that I want to acknowledge and associate myself with the personal testimonies of all of you including the members on the dais who spoke eloquently about their concerns. You heard the time element, and so, Reverend, just give me just a quick two-word, what is the imperative, Reverend, of having equality be a moral imperative? Because you started a church on that basis.
Let me just share a quote from Howard Thurman, and it's very simple. I've always wanted to know how to be me without making it difficult for you to be you.
I think that it is stunningly true. Jamie Contreras, all of us have looked at that baby and that bouncing baby with such joy, and I just want to congratulate you, and I know that this child will be wonderfully beloved and as well accepting. Tell me how deep the pain was when that baby was rejected by a physician who takes the Hippocratic Oath.
It's a pain that's indescribable, and it sticks with me to this day, and I think that's why I have to keep sharing my story to make sure it doesn't happen to anybody else, because it was horrifying. And this question that really keeps me up at night, and me and my wife, that just haunts us, is what if that had been an emergency? What if we were in an emergency room and that on-call doctor didn't want to see us? So finding another, how long till we get another surgeon or an EMT showing up at our house? So the Equality Act, what can give us finally a sense of peace of mind to just provide for our children and keep them safe like any other parent wants to do.
What a powerful statement. Mr. Brown, you hail from the state of Texas. We call it great, and that means it should be great for you. I can imagine the pain. You wear the color of black skin, who's seen such segregation and devastation, and now in your life. So would you be kind enough just to say, again, the piercing impact that you were fearful of not being able to take care of your family?
Yes, absolutely. And as I stated, when I was outed as a transgender man at work, my known transgender identity, I did not harass or discriminate against anyone. I was harassed and discriminated against. When I went to the bathroom, I didn't harass or try to make anyone feel uncomfortable. However, I was harassed and made to feel uncomfortable because of my transgender identity. So again, the Equality Act is important because it provides safety for everyone, not excluding transgender people. And also, being fired from my job so abruptly because of my identity, left me in a very vulnerable place, in a very perplexed mind state, in wondering, will I be able to secure employment again, because I'm still gonna be me. And I didn't feel that I should be reprimanded for living authentically in my personal life.
And thank you. I have dealt with this through a young man that I had come to love and had tried to help. My good friends in the audience remember when we were dealing with hate crimes, and David Richardson was a young man in my constituency. I visited him at home. And so this is his story very briefly. As horrific and painful as the past year had been for hate crime survivor David Richardson, his future seemed brighter, a chance to attend college for free, to devote his life to public service and leave behind a troubled path. The past 15 months of Richardson's life was focused on recovering physically and emotionally from a brutal attack in which he was beaten unconscious and sodomized in the backyard with a plastic pole by a man shouting white power. Sometimes these things overlap. David Richardson was a person who testified during our hate crimes hearings many years ago, but ultimately David Richardson leaped to his death in the Gulf of Mexico from an upper deck of a Carnival cruise ship. These are the stories that are unheard, and this simple legislation, H.R. 5, that is congruent with our civil rights laws and our hate crime laws, is long overdue. And I hope, Mr. Chairman, that we'll be able to pass that expeditiously. I ask unanimous consent to submit these into the record.
Without objection.
LGBT, NCA.
Without objection, they're admitted.
And others whose names they want me to call, but I will have them in UCLA. And I hope that the tone of this meeting will be that we will never, never forget. With that, I yield back within the time.
Thank the gentleman, lady, for yielding back. Ms. Garcia of Texas.
Thank you, Mr. Chairman, and I'm going to just ask a couple of questions and then yield about 1 minute of my time to my colleague, Mr. Cicilline, who will have the final words on this bill. My questions are going to be directed to you, Professor, and actually I have a lot of other questions over there, but we're in a hurry to get to our votes. This whole issue of the deeply held religious beliefs, in the way, in my view, that some folks appear to be using it to hide behind discrimination. I know that one of your panel members talked about how there was no way of knowing who is lying when they say they are transgender. I would submit to you that we never know anyway who's lying, that they really have a deeply held religious belief, and that therefore they're going to do X. And how deep is deep, and how held is that belief? So can you just tell us in like a minute or two what your analysis is of what that really means, and where that whole theory is evolving, and where it may take us?
Absolutely, Representative Garcia. The exact same thought was going through my head as I heard about this faking it notion of thinking we wouldn't abolish protections for religious minorities simply because it's very easy for you or me to say, I have a particular religious belief, so I should be able to avail myself of that religious exemption. We don't do that, even though the courts have been very loath to inquire into the sincerity or the coherence of somebody's religious beliefs as well they should. So if we don't worry about it in that context, if we're not saying let's repeal, religion as a Title VII category, then why should we have any pause about people faking it in this context? The fact that some people may opportunistically use it is no reason to deny protection from the people who really need it. So I would say that much. The only thing other thing I would add here is that the reason that we're quite leery about putting too many religious exemptions into this act is the sad history of the use of religion, sometimes sincerely, sometimes opportunistically, in order to undermine the edifice of civil rights. After the passage of the Civil Rights Act in 1964, there was a restaurateur, a barbecue owner, who said that he refused to serve African Americans on the basis of his deeply held religious beliefs. The Supreme Court said that that was patently frivolous, right? But he was not alone. There are others who said, my religious beliefs compel me not to serve across racial lines. So what we're seeing today is individuals who are saying our businesses are otherwise open to the public, saying that on the basis of my religious beliefs, I will not actually serve you, even though I'm otherwise open to the public. And to answer the question that was posed to Ms. Contreras about whether or not the physician on deeply held religious grounds should have to serve a Nazi patient if they were Jewish, I would respond in the same way that I heard Mr. Cicilline respond before he was cut off, which is to say Nazis are not a protected class. And what we're trying to do here is to make sure that transgender individuals and individuals who are gay, lesbian, or bisexual are that protected class. They do not have to suffer the searing indignity that Ms. Contreras went to, because for her to have to go to another doctor is the same as for that black patron who was refused from Piggy Park to have to go to another restaurant. It doesn't matter that there's another barbecue down the block. The memory of being denied that service simply on the basis of your race, or on the basis of your sexual orientation, on the basis of your gender identity, lives with you for the rest of your life.
Well, thank you for that, because it's troubled me, because I come from Texas, and we fought the bathroom bill, just tooth and nail, and it seems that more bills have crept up, whether it's for faith-based organizations denying, any LGBTQ members from adopting, from foster care, the pharmacist not dispensing medicine. In my view, it's sort of like they're getting carried away with it. But so thank you for that. And Mr. Chairman, again, yield now the remainder of my time to my colleague who's worked so hard on this bill, Mr. Cicilline.
I thank the gentlelady feeling. Mr. Chairman, I would just ask, I know Congresswoman McBath went down to vote and had a very eloquent statement that she intended to give. I'd ask unanimous consent that it be put into the record twice to reinforce the power of it.
It will be put into the record 3 times.
And Mr. Chairman, I have 9 articles that I'd ask to be made part of the record.
Without objection for all 9 of them.
Finally, I just want to end where I began my comments and thanking you, Mr. Chairman, for this historic hearing, for these extraordinary witnesses, and for any young, gay, lesbian, bisexual, transgender youth out there who's worried or feels discriminated against or fearful. Help is on the way. Thank you, Mr. Chairman.
Thank the gentleman. I thank the gentleman for introducing the bill. This concludes today's hearing. Thank you to our distinguished witnesses. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. The hearing is adjourned.
You're amazing. I agree with that.